Adjournment request, if any, from item number 1 to 3. From item number 4 to 14.
May it please your lordship, with the consent of the other side, I'd beg to mention item number 4, your lordship.
Yes.
Your lordship, I circulated an adjournment form yesterday as the Arguing Council is out of town.
That's right. Have you informed the other side?
Yes, your lordship.
You have circulated and have you telephoned him also?
Your lordship, I've taken the signatures.
All right.
The-
All right. This is item number 4.
Yes,
Four.
your lordship.
Yes, as prayed for. You want 2 weeks?
Your lordship, yes.
2 weeks?
Yes, your lordship is convenient, your lordship. Much obliged.
6-8.
Take the dates also. I
6-8.
say 2 weeks, but the date is specific.
May please your lordship. With the consent of other side, I beg to mention item number 11, lordship.
Yes.
In this case, I pray for some accommodation, lordship. Lordship, can you take up the matter after 3 weeks, lordship? In this case, learned
You are
advocate,
appearing for the
state of Mizoram, lordship.
state of Mizoram.
Yes. Learned advocate general will appear in this case. Act is challenged in this case. After 15 August, lordship, any date.
As prayed for. After having taken consent of the other side. So and so.
Obliged.
May it please your lordship. Lordship, with the consent of the other side and on behalf of the appellants, lordship, I beg to mention item number 6, 7, and 8, your lordship.
Yes.
Lordship, I have circulated this
That we have seen.
adjournment slip, lordship.
What do you want?
Lordship, can it be fixed on 11th, lordship? Lordship, we have to file an IA to change the appeal, lordship.
Now you tell us the week of adjournment, dates we will fix according to our calendar.
Lordship, 3
After
weeks.
2 weeks, after 3 weeks, after 1 week,
Lordship, after 2 weeks, lordship.
don't fix the date.
Lordship.
Leave that to the court manager. All right?
Lordship, because the arguing
3
council
weeks,
is.
Ocha, we have fixed a council there.
Yes.
You will have to fix a date first with the court and then with the council.
Lordship.
Then on 12, Lord, 12,
No, 11, can it be 11?
11 Monday, not a.
No,
Not a hearing there.
lordship, only it will be come up for orders, lordship. It, we have,
Do it. 11.
11.
obliged,
All
lordship.
right.
May it please your lordship, with the consent of petitioner side, I beg to mention item number 13, lordship. And
Yes.
for the respondent side,
Yes.
kindly adjourn the matter for 2 weeks, lordship.
As prayed.
Lordship.
8-8.
May I please, your lordship?
Yeah.
With respect to item number 14,
Yes.
lordship was one of the counsel in the petitioner's case. Your lordship might not take up the case, lordship.
Item?
14,
Yes, that was in the 8 of 2010,
lordship.
WPC, 8 of. That I will.
Take up. Let this case go out of our list and be placed before a bench of which Honorable Justice Michael so-and-so is not a part. The file be put up before the Chief Justice for allocating the bench. Yes.
Much obliged, lordship.
From item number 15 to 25, adjournment request.
May it please your lordship,
Right.
I beg to mention item 22, my lord, we had circulated an adjournment slip yesterday.
Hmm.
A learned additional advocate general has some difficulty today, my lord. Any date may be fixed, my next week,
Tomorrow or next week?
29th of
No date. You tell us the week. Date, my court master will do.
29th, my lord.
Week. देखो whether it is true week. All right. As prayed for. देख लेना
29th
किस साइड का है.
Obliged.
Let you not say as prayed, as jointly prayed. Yes.
May I please your lordship? Lordship, with the consent of the petitioner, lordship, I beg to mention item number 23.
23.
Yes,
Yes.
lordship, as my senior, Mr. S.K. Mehdi is not well.
That's
today.
right, but this is a fixed case, no?
Yes, lordship, as my senior, Mr. S.K. Mehdi is not well today, lordship, kindly may.
Who is your senior?
S.K. Mehdi, Sanjay Kumar Mehdi.
Mate.
Yes,
He's not well.
Well today, lordship. So, lordship, kindly fix the matter on August, 7th of August.
I think I'm loud enough to let you know that you can't fix a date by yourself. That is the convenience of the court. You can ask for accommodation, we grant you accommodation on your asking, but don't fix a date.
After 2 weeks, then lordship.
2 weeks. I mean, this is just for your consumption that if you ask for dates like that, you would be catering to your convenience only. If we are looking after your interest, you look after the court's interest also. It has to be mutual, no? So we accommodate, then dates we can negotiate, but later. After 2 weeks.
Yes, Lord.
2 weeks would do?
Yes, lordship.
All.
Any other request?
Meet please, Your Lordship. May I pay permitted to move in at April, my lord, tomorrow, my lord. Agencies that, my lord, and one temporary employee is sought to be replaced by another temporary employee, my lord. I was holding the charge of, my lord, assistant protector officer in one post, my lord. On the basis of recommendation of MLA, my lord, I was sought to be transferred, lordship. So agencies there, my lord, can it be taken tomorrow?
How do you know that?
My
Does
lord,
the transfer order say that it is because of the recommendation of the MLA?
note was there, my lord.
Note is all right, that's for internal
Okay.
consumption. But then what is the urgency? Go and join, we'll
My
see.
lord, I am directed to join.
We'll see if it is a punitive transfer. We'll see if it is beyond policy, we'll see, but no urgency. Yes,
May please, Your Lordship. Lordship, I am paying for a listing of review petition, my lord.
listing of review petition.
My lord.
Review against which judgment? Passed by division bench, this bench.
This bench, my lord.
Review next week. Next week.
May I please, Your Lord? Lordship, I
Give the slips. Oral mentioning would not do. Give your slip. Yes.
Lordship, I beg to mention for listing, Lordship, read appeal, Lordship. It was filed by the government, Lordship, but it was filed on 7, Lordship. 7/7/25,
How long
Lordship.
does it take for a writ appeal to be listed normally? I don't know how long. No, you want it to be listed. Give your number. Have you filed it in the register?
Lordship, it was filed by the government, Lordship, on
Is it
7,
defect free?
Lordship.
Is it defect free?
Maybe, Lordship, defective, Lordship.
Oh, you're.
Filed by the government, Lordship,
You are
but I am
respondent.
suffering, Lordship. I am respondent number 1, Lordship.
But nonetheless. We'll list. Take a note. Find out from the registry why it has not been listed.
Yes.
Lordship,
New file.
deeply obliged.
New file.
Yes.
Number 2. Daily list for admission, item 1.
Please, my lords. Am I audible, my lords?
Yeah, audible and visible both. Yes, sir.
Oblige, my lords. My lords, this appeal, this petition is coming for the second time. On the last time, my lords,
Can you
the
first
court
introduce yourself?
then had
Would you
asked
introduce-
for particulars of people who
Sir.
had gone. I'm sorry, my lords.
Just a minute. You have to give some pause when you appear virtually. See,
Yes.
the court would be asking question. If you continue talking, then perhaps.
Please,
they'll-
my lords. Please, my lords. I'm sorry.
No, not at all. Introduce yourself since you're appearing virtually. Introduce yourself. Who are you?
Please, my lords. My name is Sanjay Hegde, my lords.
Yes.
I am appearing from Delhi.
All right. I couldn't see you. Yes, Mr. Agde. Continue. Yes.
I'm sorry, my lords. I'm sorry, my lords.
Yeah.
This petition challenges the action of the state of Assam and the Union of India
Yes.
in forcibly what they call pushback of certain people. These people, many of them have
Yes.
not even had the benefit of any judicial process. Many of them have not even been declared by any competent judicial authority to be foreigners.
Yes.
And in this case, my lords,
Yes.
when it came up for the last time, the bench wanted to know whether there were any particular cases that this organization espoused. So now we have filed a detailed affidavit listing out at least 21 cases, which is set out at page 95, I assume, 94 and 95.
So they have been deported or they are about to be deported?
They've gone missing. We do not know where they are.
That's right. But then would they fall in the category of people who are being pushed back?
My
See,
lords,
if you don't know, they may be missing for other reasons. How are
please,
you?
my lords, we have stated that they have been detained and then thereafter
Yes.
we do not know their present status. Their present status, we have said that they are missing. They were detained by the state authorities.
Okay. And
My lords,
thereafter they are missing. So
I'm
you have
sorry.
given a list of how many? 21.
21 people.
And the date and the date of detention. Were they detained or were they summoned?
My lords, many of them were detained. There has been no formal summons as
No
such.
formal summons, but
There was no court action before the detention.
All right. So when did you file this affidavit? Has it been served on the other side?
Please, my lords.
Mr.
My
Advocate,
learned friend, Mr. Razak Bhuiyan, who appears with me, will inform your lordship.
This month 16/7/2025 we have filed.
Mr. Advocate General.
Yes, Lordship, in terms of the order of 27th of June,
Yes,
they were supposed to give the list.
yes, they have given the list.
Yes, now they have given, so we are verifying. So we need some time because we have received one set of instructions without this affidavit.
That's
prior to
right,
this.
Mr. Advocate General, you'll have to be slightly more prompt in these matters.
Absolutely, Lordship,
Because
but there was a
it's a matter of
vacation going on
detention.
during that time. During that time, it was on vacation. And that is why immediately, in fact, with this petition, we have raised the issue of maintainability. A very vague petition was filed
That's right.
without
I've
any
seen the order.
details. Now details have come, I think 3 or 4 days ago.
There are other details which are wanting, but
Yes.
then you find out from your resources, because
Lord.
you're the state, they were asked to be present. They were to be interrogated. Some of them were detained, as is the allegation. So therefore, you will be having the records.
Absolutely,
Now, if the
Lordship.
names have been given, you please find out and tell us whether they were subjected to any judicial proceeding, whether there was any inquiry about them that they are foreigners.
Yes.
And if at all, then perhaps the process of law has to be effected. No, you just.
In
can't-
fact, there is no violation. In fact, the identical case is going on in Supreme Court where we are submitting all the details from time to
All
time.
right, all right.
Identical case is going on.
So, but then.
And we are following the directions passed in that.
That's
particular
true,
case.
that's true, but some of them are missing since
So
I mean, month of May, most of them.
My
So this appears to be one.
that is why they have to identify. Because we have the detention camp, we have the holding camp, and we have the foreigners
That's
tribunal.
right.
They are within the ambit of one of these forums.
He says, no,
Either they are in the holding camp
Mr.
or in the detention camp, or they are facing proceedings either in this court or in the
Therefore,
foreigners tribunal.
you will have to indicate that.
That is why identification, they have to give us the particulars. That particulars have come to us 3 days ago. Lordship, would kindly give us some reasonable time to verify.
And
For
what is this, what is this reasonable time? You tell us, Mr. Advocate
1
General.
week, Lordship. I am
1
not
week?
asking. Yes, Lordship.
This is very prompt. As prayed for by the learned Advocate General, let this matter come up for consideration
Monday next, Lordship.
on Monday next. Mr. Hegde, all right?
Please, my lords, I'll endeavor to be there.
All right. All right.
I am always cooperating, Mr. Hegde, Lord.
No, no.
28-7.
All right.
Obliged.
28-7.
Highly obliged, Lordship.
Item number 2.
Mr. Advocate General, there is a request.
Yeah.
There is a request to you
Lordship.
for about 10-15 days, just find out time. If you're not otherwise held up in any other
No,
court, you
Lord.
please be here, because there are certain things which I need to ask from you
Lordship.
as the first law officer of the state.
Highly obliged.
And there are certain, state laws where the fault line lies. So I'll be putting it to you. You have to respond.
Lordship.
Of course.
Only tomorrow I am little bit not
All
available.
right.
Otherwise,
All
I am
right.
always
So,
available.
whichever matter you're appearing, that's all right. But in
Lordship.
other,
I will be
other
present, Lord.
contentious matters, you be here for
Few
giving a
days.
state's view.
Lord.
Because we believe, and the Supreme Court says so, that concession only by the Advocate General is acceptable. So we will
Lordship.
ask for such things from you.
Highly
Right, Mr. Hegde, on the next Monday.
Obliged, my lords.
obliged.
Item 2.
May I please, my lord?
Yes.
My lord, this matter has come under the admission column. However, my lord, by the order dated, my lord, 2/12/24. My lord, this matter has already been admitted. So, my lord, it ought to have come for hearing. My lord,
What is this matter about?
my lord, my lord, we have challenged the order of the learned single judge, my lord, by which there has been a direction to pay to the landowners, my lord, who were occupiers of a government land.
Compensation under the land.
So,
Acquisition
my lord,
Act.
No, but government land. they
There's
say.
government land.
Can you place the order by
yes,
the learned single judge? Page.
page 248, my lord.
I think the government has.
278, I'm sorry, my lord. Page 278.
Page 248.
278, my lord. 278, it starts from, my lord, and page 290 is the operative portion.
The portion from where the judgment starts, my lord. Page 290.
Yeah. No, I don't think your paging is in sync. I'm the page. You're paging backward.
I think this is page 298,
My lord, 298. I'm sorry, my lord. It has-
99/2022.
Yes, yes, my lord.
298.
298. Where's this one? Just see.
Flagging is not correct. Flagging is not correct. No. But who was he? This Mr. Kinkar Das.
Yes, my lord.
He was executive engineer construction,
My lord.
and the railway says that this is not correct.
My lord, the
Division bench. also.
what was agreed to, my lord, in this case, what has happened, my lord, there was no process of land acquisition carried out.
That's something
Apparently,
else.
there was no land acquisition at all.
That's something else.
What we have paid, my lord, and what the officer has agreed to was only the lease charges to be paid, my
There
lord.
is a division bench order also, I think.
Yes, my lord, there is a division bench order, my lord.
Point of
and-
that order is the order
Yes.
dated 2/12/2024. that
6,
correct?
6 to 24. Not 20.
2/12 something.
It's separate.
It's the order. All right, so have the respondents appeared? All of you, all 150.
Yes, my lord.
So
We are
we
there.
will hear it. You'll have to prove the case. There is no documentation of your land. You could be an encroacher. Merely a concession of a deputy engineer of the railways, where the railways denies that the officer was competent to give that concession, to make that certification. We'll hear you.
Yes, my lord, not that. What happened? The railway authority admitted that we are remitting the compensation. We are paying it, but we are paying to the deputy commissioner.
It is not their property. They are not the custodian of the funds. They may
That
say
is why, sorry,
They may say anything. They are not the custodian of the public fund.
No,
Now,
my lord.
first, your entitlement has to be determined.
exactly, that has been determined by the deputy commissioner. It was sent
Deputy
to them.
commissioner is no authority. See, the purpose is this. If the government says that this was a government land, then perhaps you would be required to prove, or the government will be required to prove that this is not the private land, but the government land. And therefore, if you are an encroacher, you can't have compensation.
My lord, respectful
Therefore,
submission-
we say that the order shall remain in abeyance and we shall hear out.
Yes, yes.
Take it.
I'll take your lordship to all the relevant things.
That's right.
Yes.
My lord, there are two state of cases, my lord. One state, my lord, there are holding government land. The other state, my lord, some of them, my lord, they are the Patala. And the so far the Patala is, they not put the land has not been taken. My I have, my lord, that the land so far the Patala owners are concerned, their compensation may be released.
That would be.
That was also acquired subsequently, my lord.
That is difficult.
And
Take it.
secondly, my lord, so regarding.
The respondents have appeared in this matter. By an earlier order passed by this bench, the operation of the judgment of the learned single judge had been stayed. This writ appeal has been admitted for final hearing. List this case for final hearing on, we give 2 weeks, get ready. We give you priority.
Yes.
After 2 weeks, within first five cases of hearing. After? Give a date anytime after 15th of August. Be ready with all
21st.
documents, we will decide. Needless to state that the interim order of stay of the operation of the judgment shall continue.
Documents are there on record, my lord, to show that we are not encroachers, my lord. He is my apprentice.
We'll see.
Yes.
21-8.
If you're not an encroacher, that is your land, and if we see that money is being held back from you, we will pass orders. But then it has, I mean,
Yes,
we not, I mean,
Only Patta is not disputed in favor of some of the, but we are entitled.
we'll see. On that day, you argue.
But the interim was still the disposal of the matter. On the
Till the disposal of the matter, interim, we can't allow it to go for eternity. Therefore,
No.
it's a reminder to us.
No.
It's not a reminder to you. It's a reminder to us that we need to, if we have stayed the
No.
operation of the judgment, we need to have a date fixed.
my lord.
Any date within first 5 cases of hearing.
On the
21-8.
Yes, I know. Whenever lawyers appear, senior lawyers appear, to give me a slip about his name. Huh? It's not good calling them Mr. Counsel. Huh?
KK Mahanta.
Item number 3.
May it please your lordship.
Yes, madam. I'm back. Yes, Mr. Chaudhary.
Yes, my lord. In this case.
See, after 10 days, I would be referring to all of you by your names. I mean, therefore, I have given instruction to the Yes.
My lord, now what had happened, my lord, we came before this honorable court with 2 grievances.
Hmm.
Now, one of the major grievances has already been considered by the state.
Right.
If a lordships would just opposite the old building and in front of the present building, my lord, after that Diholipuri tank, there is a state museum. There are about 26 number of mature trees, my lord. Those were sought to be removed for facilitating construction of a flyover.
Yes.
There was a tentative proposal of the state. Partly against that, we approached this, filed this petition.
Right.
Now, on last occasion, the learned advocate general made a statement based on instruction that they are not going ahead with that. Therefore, that was recorded. That part of the petition is over.
Grievance is over.
Now, my lord, at the same time, about 70 odd trees, no? 76 odd trees in the near vicinity have already been translocated, my lord. Now, all that we are trying to say is, my lord, some mechanism has to be worked out to monitor this, my lord. Because what had happened in Delhi, my lord, there is a statute. Recently, my lord, Madras High Court has constituted a committee of experts and civil society representatives, apart from government representatives. So we are praying for the present, my lord, I think I will confine my argument to only that. May I place the 2 orders, one of
Yes.
the Delhi High Court and other is of, my lord?
That is given.
Yes,
That
that
is
no,
given.
Madras High Court order, my lord. And Delhi, yes. Now, if your lordship should kindly come to second page, my lord. Writ petition filed under Article 226 of the Constitution of India, seeking for issuance of a writ of mandamus, directing the respondents to form a committee consisting of all the experts to preserve all the trees which are situated in rural.
That's right, Mr. Chaudhary.
Yes,
We understand.
yes.
That was a prayer. That
Yes,
was-
and that has been accepted, my lord. Now, even government of Tamil Nadu, they themselves came up with an OM, my lord, saying that they will issue an OM whereby they will constitute a committee. And in fact, the agency which was engaged by the state government in the present case, their name does not figure in any of the 3 government and 12 private agencies recognized by the state.
Mr. Advocate General, the grievance is genuine.
Yes.
You'll have to consider, the state will have to consider that there has to be a process of translocation. Because the experience is that if the trees are very mature, if they're more than 10 years old, transplanting would not be feasible. 1, logistics problem, and number 2, it might not succeed. The tree dries up, you know. This is the way the mother nature behaves. So
Lord.
if something could be done, this is no adversary litigation. We have to keep our urban area green. At the same time, Mr. Advocate General, Mr. Chaudhary would agree
Yes,
that the infrastructure development is necessary.
has to be there.
If you don't have highways, if you don't have overbridges, perhaps it'll be difficult for people to
Correct.
communicate, to commute. So a balance has to be struck.
Yes.
We need green urban and rural areas. So what can you do, you tell us? I mean, we are not straight away inclined to constitute a committee, especially when the state,
Lord.
if the state takes over the responsibility, the state summons the authorities from the forest department, horticulture department, they should be well equipped with the idea. I mean, they should know. I have my personal experience of, arranging for this kind of advisory body for locating trees, old trees, 50 years old trees from Patna High Court campus, because a mirror building was being constructed when I was there. 10 big trees were translocated, 8 dried up. Only 2 survived. And that also had to be felled because of the construction necessity. Right. So this is not an adversary litigation.
Lordship,
Look into it.
Yes.
In what do you say about the felling of 23 trees?
We have clarified. In fact, we have given the report at the very first stage, Lordship, that we have identified 77 number of trees which are to be translocated, out of which 23 were optional. So we have realigned the bridge without touching these 23 numbers within the campus of the State Museum. That is number one. Initially, this is the second round of litigation by the same petitioners. When we proposed to have the bridge till the end of the tank, then we had to identify few trees which will be either translocated or they will be
You have given the
trimmed.
affidavit.
No, that is in the first round. I'm giving just the background. So we gave a commitment before this honorable court that we will change the design, and we have in fact done it
No, Mr.
without touching any of the
Mr. Saikia,
Lordship.
every time calling you Advocate General doesn't look nice. Mr. Saikia, that part is over.
That part is now I'm
There is-
coming. I'm coming to the next stage. I'm coming to the next stage, Lordship. So while realigned and new design has come up, we have identified 77 number of trees. That is not within the tank. That is on the street, on the road. And out of which 23 were identified, which is an optional scope for us. Now we have such a design without touching those 23. We are going ahead. We will not touch it. On affidavit, we have stated already.
Okay.
Now, regarding that 77 number of trees, we have translocated 76. One is yet to be done. And I have received a written instruction. All are growing. Their new leaves are coming up in the new translocated areas. It is a successful exercise. And this is for the first time we have adopted this. Otherwise, for other constructions in the state, not only in Guwahati, we have removed all the trees. We are in fact cut the trees, not translocated. This is the first time on experimental basis we have done it, and it has been successful, Lordship. And we are taking a cue from construction of the Assam House in Delhi, Lordship, where 2 trees we had to be translocated. That has been done. That is also successfully being done last year. So now we are taking a cue from that exercise. We are doing it in Assam. For that, we have involved an agency from Delhi. They are doing it, Lordship, and out of this 76, all are now blooming.
No, that's right. This certification by the Office of the Executive Engineer doesn't satisfy us.
No, this is just an up-to-date information.
So the agency from Delhi, is it a private body that you have hired?
Yes, Lordship.
And are there horticulturists there?
That instructions I have to take,
Take instructions.
Lordship. And on the other hand, we have policies regarding afforestation, deforestation, everything. We have a policy. We have a rules also that covers if we remove 1 tree, 10 number of trees has to be transplanted. For that, substantial fund is already there. Last year, we spent about more than 6 crores for plantation.
All right. So for felling or translocation,
this is the first time we are doing it, Lordship.
also some clearance also has to be taken, no?
Yes, there is a guideline, there is a SOP of the Forest Department.
No,
We are
there is a
following that,
Central Environmental Impact Assessment Authority, as I understand.
Lordship.
Are you aware of it?
Yes, Lordship. I have the SOP where everything is in.
No, we are talking about this.
The central authority, Lordship.
This environmental impact assessment authority.
Yes, that is when a project is being to be done.
Yes.
This is not a project, Lordship, that kind of a project. We are just removing the trees at the edge of the road. For this,
That's right.
if we have to have suppose we have to have a greenfield airport, there all these necessary exercise has to be done, which we are doing in Silchar. The new airport, greenfield airport is
That's
constructed.
necessary. Nobody will deny this. It's
Lord.
necessary. Nobody can deny this. Our concern is, and the concern of people at large would be that it should be done in such a manner
Absolutely,
that
Lordship.
you don't go for afforestation totally.
Yes.
And it should be within the rules, with the rules, in consonance with the rules.
Let me file it through an affidavit, all the rules and SOPs, Lordship, that will clarify, because this rule is called Assam Trees Outside Forest Sustainable Management
Also,
2020.
so that we are satisfied
Yes,
that you have
Lordship.
taken all care.
Absolutely, regarding captive plantation, certificate of origin, everything has been incorporated.
All right. We would
Very
like to see-
detailed.
We would like to see that.
Yes,
SOP
Lordship.
And your certification, that is state certification.
Lordship.
That this translocation or felling or uprooting trees is in consonance with the SOP.
Absolutely, Lordship, and we are more encouraged by this exercise now. That we could save all the 76
It's
number
very-
of trees.
It's very heartening to hear that these mature trees, 70s out of 77, 76, they have.
Survive.
There is a foliage there.
Yes.
So therefore they have survived. Yes, Mr.
My lord, let state come up with
We
their.
should not be so negative, Lordship. We should sometimes appreciate also. I'm talking from the perspective of the PI list also.
My lords, at times, my lord, even
I have given the
When
photographs also.
non-adversarial litigations are taken as adversarial, my lord, this is the perception.
The problem is that this PIL has been filed by saying that we have violated the commitment given to this honorable court.
Mr. Saiti and Mr. Chaudhary appear to be very, very senior advocates of this court. That is my presumption, and I think it is factually correct. So unless these kinds of, cross arguments are made, the judges don't feel elated. So we accept this. You can
No,
call him.
the main trigger point of the second PIL is that we have violated. That is the main contention, which we have not done.
No, it's all right.
My lord, only thing is, my lord, from our limited perspective, my lord, there should be some authority to take a call, my lord,
No,
when
here-
it is required.
Chaudhary,
Yeah, yes,
It's all right.
yes.
Therefore, we asked him, let us see the SOP.
yes, yes.
We need not strain ourselves to that
Very correct,
extent.
very correct.
If there is an SOP.
Let us
and
not
that
draw
takes
any
care of
adverse conclusion without, yes, very correct.
All right, take note. We have heard Sri Chaudhary. We have heard Sri Chaudhary, learned senior advocate for the petitioner, and Sri Saikia, learned advocate general for the state. A concern was flagged about felling of large number of trees for the purposes of construction of elevated GNB road flyover. No sooner was this issue flagged, the learned advocate general on instructions assured the court that necessary changes would be brought about in the alignment of the flyover, which would make the felling of trees or its translocation at that site completely avoidable. Mr. Chaudhary, learned senior advocate, submits that such assurance has been carried out and there has been a realignment. To that extent, the grievance of the writ petitioner has been redressed. However, it has been pointed out that some of the mature trees are being translocated, which might not survive the vagaries of nature. Responding to the aforenoted concern, the learned advocate general on instructions has submitted that a good number of trees were identified which had to be translocated. Necessary inputs were taken from the experts, and out of 77 such trees, out of 77
Yes, Lord.
trees which were translocated, 76 have survived.
Till now, we have done 76, 100% success.
Out of 77 identified trees, 76 were translocated, all of which have thrown foliages suggesting that they have survived. This is very heartening to note. We have requested the learned Advocate General for the satisfaction of the petitioner as also ourselves, whether the SOP in this regard exists and whether such translocations / felling for construction purposes are in consonance with the SOP so formulated. This court has been assured that on the next date, an affidavit shall be filed along with the SOP and a certification that all care is being taken to preserve the trees while carrying out construction work. It needs be reiterated that a good balance has to be struck. And without good balance has to be struck, and all care has to be taken for preserving the ecological balance and maintaining the greenery. We see it as not an adversarial litigation, but an endeavor to sustain the Mother Nature for the posterity. Relist on.
Monday next, Lordship, I'll file it by Friday.
Monday, we have fixed many matters, 2 weeks.
Lordship.
4th of August. Supplementary list for admission item 26.
Which is the number? Number?
Supplementary.
Yes.
May it be the Lordship. This is a writ appeal, my lord. Challenging the order dated 17/7, my lord.
Louder, sir, louder.
My lord.
You have the mic before you.
It's working, my lord. My lord, this is a writ appeal, my lord. Challenging the impugn order passed by the single judge on 17/7, wherein the relaxation of the upper age limit has not been condoned and the writ petition was dismissed. The writ petitioner
Show us the order. Show us the order.
Lordship will find it, but says the 136, 137,
137. How do you manage to get it?
The business include here. Well, for example, the developer, person actually 38 years. He was 42 years. That is the.
We'll discuss it. Yes, place the judgment.
Yes, madam. But the judgment starts from page 139.
139, yes.
My lord. First of the
30 and 14. Yes, sir, you have no case. The learned single judge is absolutely right. Heard, mister?
Before that, but passing the order, madam.
When you say, when you accept what I say,
Madam,
that means,
I accept the lordships, madam.
that means I have
Madam,
now the authority to pass an order.
let me submit, madam,
Yes.
to some point, madam. The lead appellant was working for 7 years in that department, madam, as a fishery expert. And during his tenure,
Yes.
the impugned advertisement was published for requiring 65 numbers of fishery development officers. But as per the service rule at page 94, rule 7 says that the upper age limit should be 38 years as on 1/1/2025. But my lord, if your lordship comes to
Rule 25.
25, my lord, but it says that if any hardship is caused, my lord, while interpreting this rule, any of the rule can be relaxed. So, and as per this, my lord, the first petition, what is the page number? Not at page 111, petition, my lord. This honorable single judge, my lord, lordship will come at page 113, my lord.
Yes.
Here an honorable single judge says that since there is a provision in the rule of 2024 for relaxation of the operation of the rules under which the recruitment process is to be carried out, if the government is satisfied that undue hardship is caused in any particular case, and considering the fact that the petitioner has also submitted a representation, hence there can be no justification for the authorities not to consider this prayer in accordance with the law and dispose of the requisition without any delay. But after passing this order, madam, it was forwarded to the department. What did they do, my lord? Kindly come to my lord, page 119. My page 119. This was passed on 30/4/2024. Here they says, madam, at para 8, page 120, thus in the instant case and after careful consideration of all documents and facts.
Sir, you don't have a right to be considered, but then let's see the rejection order by the authority.
My lord, this is the rejection order.
With respect to the hardship, where is that?
But this one, my lord. I'm
Page?
sorry, page 119. Para 8 at page 120.
Page 119.
119, therefore, my lord, page 120. Next page. My lord, para 8. They says, my lord, thus in the instant case and after careful consideration of all the documents and facts, the request of so and so for relaxation of the upper age limit is hereby rejected. As there is no provision for such relaxation of unreserved candidates applying.
Now you
for-
tell us, the department has not considered, the learned single judge has not considered. You tell us what is the hardship.
My lord. My lord, we have seen in cases.
That you have worked for 7 years on contractual employment, is
Yes,
all right?
yes, ma'am. On the
Now
same
you have
post,
lost your age.
loss of my age.
This is the policy of the government, not to have the outer age limit of 38, beyond 38.
During my tenure, my lord, of 7 years, they never published any advertisement when I was within the limit, my lord. Yes, my lord.
That's true.
And this is my last chance, my lord. After this, I'll have no opportunity for service, my lord, government service. My lord, what is my prayer, my lord? My prayer is to allow me to sit in the recruitment process, my lord. I'm not seeking any appointment, my lord. Only to sit in the recruitment process, my lord. That is the simple prayer, my lord.
We are sorry, we can't oblige you. Take them.
And my lord, if you're not see the Umar Devi's judgment. on the-
Uma Devi has no application here, sir.
No, my lord. My lord, kindly see para
Uma
55.
Devi, we know paragraph 57, we know the
55,
other
my lord.
paragraph we are aware of.
But 55.
Uma Devi is nothing here. If you have to cite any case, cite a new one,
My lord,
which is explained.
But
By
it's,
Justice
it's,
Vikram. Gul. What is that judgment where?
well, Umar Devi says, my lord, If sanction posts are vacant, the state will take immediate step for filling those posts for a regular process. But when regular recruitment is undertaken, the respondent so and so and those in the commercial so and so similarly situated will be allowed to compete, waiving the age restriction. So it's specific, my lord. And at that time of publication of the advertisement, I have been published, my lord.
You are also compatible with person also close.
That is the hardship. That is the hardship. That is not a bird. He says that there is no rule. But on the other hand, there is a rule in 25. In case where there are applicants for undue.
He is interpreting the.
Satisfied the satisfaction has to be a operation of any people. They have chosen by the question. If any question arises related to them, that's it. Right, Mr. Das, learned advocate for the appellant, and Mr.
P. Sharma.
P. Sharma for the state.
Fisheries department.
The state. I think you're right.
Please say badminton.
P. Sharma for the fisheries department.
TJ Master, Mahanta.
Mr. T.J. Mohanta, learned senior advocate for the fisheries department. No, FPS.
Assam Public Service Commission.
वो सब लिखते रहना, Mr. Mohanta and Mr. T.J. Mohanta, learned senior advocate, assisted by so and so person. The appellant is aggrieved by the judgment passed by the learned single judge, wherein his prayer for consideration of relaxation of upper age limit for him to participate in the recruitment process has been rejected. The records reveal that the appellant / writ petitioner was in the contractual employment of the department, and after having served for 7 years, wanted to participate in the recruitment process for which advertisement was issued. However, by that time, the appellant had come of age and had become 40 and was 42 years old. The advertisement specified the upper age limit for consideration of the candidates to be 38 years. To be 38 years.
As on 1/1/25.
As on 1/1/25. The relevant service rules, namely the Assam Fisheries and Aquaculture Service Rules 2024, provides that a candidate for direct recruitment to the service shall be minimum 21 years and maximum of 38 years, or as notified by the government from time to time, on the 1st January of the year of advertisement, with relaxation in case of candidates belonging to special categories like SC, ST, and any other category as laid down by the government from time to time. The appellant has not been able to show to us that he fell in any of the categories for which there could be a consideration for relaxation of the upper age limit. However, the grievance of the appellant is that Rule 25 of the Assam Fisheries and Aquaculture Service Rules herein of 2024, hereinafter called the rules for convenience, does provide for relaxation in cases where there is undue hardship. The department has inherent power vested in it to exercise such discretion in appropriate cases. it has been pointed out, and the records also reveal that under the orders of this court, the appellant had made a representation before the department for consideration of his case in view of the provisions contained in Rule 25, about which reference has been made earlier. The department, the Commissioner and Secretary to the Government of Assam Fisheries Department.
Page 120.
No.
Page 119 and page 122.
122 is the relevant.
Oh, okay.
122 Fisheries Department rejected the prayer of the appellant on the ground that there is no provision for any relaxation for unreserved candidates.
My lord, may I come in this?
Just a minute. Unreserved candidates applying to grade 1 and grade 2 posts as per instructions of the personnel department. Mr. Das, while conversing, his case has submitted that the department did not consider the provisions contained in Rule 25 of the rules. And this was not taken in the correct perspective by the learned single judge. We find that the learned single judge referred to the provisions contained in Rule 25 of the rules of 2024, but held that the inherent power vested in the department under Rule 25 is to be exercised in case of deserving case, in deserving cases requiring such consideration. And that Rule 25 cannot be read in silos, but has to be considered in a perspective which remains consonant with the basic rule of the minimum and maximum age limit provided in the service rules, service recruitment rules. The grievance of the appellant, therefore, is that what could be a better case for consideration of hardship when the appellant remained in contractual service for 7 years, and despite vacancy of such position in the department, no recruitment process was initiated. No recruitment process was initiated. The truth is that recruitment process in a department has to be prompt, and the process should get kick-started on an annual basis or subject to the vacancy position. But that cannot be taken as a ground for considering the hardship as contemplated under Rule 25. The petitioner may have lost out on age, and the appellant / writ petitioner may have lost out on age, and any further prospect of working with the government. But so would be the case with respect to many others who have crossed that age. A person has a right to be considered for a government post. He has a right to livelihood, However, these rights cannot be translated into however, these rights cannot be understood to mean that the recruitment rules in general would be ought to be bypassed. We find the judgment passed by the learned single judge to be absolutely in consonance with the proposition that the recruitment drive should be under the parameters prescribed in the recruitment rules, and any deviation in the form of relaxation of age should be on a careful consideration of the hardship, which is an unusual hardship. The appellant would have many other opportunities, would have many other avenues. And he cannot claim that he has a right to be employed in government service. Finding no fault with the learned single judges, with the judgment impugned in the present appeal, we dismiss this petition.
Madam, there are two impediments, madam. One is on 35 and another is on 5.
Actually, we have considered it. We have considered the rule, lordship. He has shown the superseded letter, lordship.
Which case, which item?
In this letter, lordship, in this.
It's 120, madam.
He has shown the 119 letter. Actually, we have two letters. Two orders, lordship. Actually, we have considered, while passing the order, we have considered the rules, lordship.
But there are two impugned letters.
Yes, madam.
Yes,
Two, madam, 122 page number.
122 page number. We have
Yes.
considered.
Why do you get up? Why do you get up after the order is dictated? You should have pointed out, no?
Lordship, lordship was dictating, so I prefer not
I tried,
to
madam.
disturb lordship.
Which is the other letter?
122.
122.
122.
Page 123, last paragraph, lordship. We have said, after careful consideration of all documents and facts, the request of Mohammad Abu Subhan for relaxation of the upper age limit cannot be considered as per Rule 25 of the Service Rule. As per Personnel Department has clarified that there is no office.
Same thing.
Yes.
Same thing. What have you considered? You have not considered any.
No, lordship.
You should have said that there are so many other people who have crossed the age
In
and
the
we have not
earlier
given
letter, in the earlier letter, we have not considered a service to lordship.
Daily,
you would have got a experienced hand. But since, I mean, we cannot pass a mandamus unnecessarily without there being a right. I mean, you should have considered 38 and 42, and I mean, that's not a big age gap. But then this happens, he cannot be the only one, only chosen one.
Yes.
And that would be unfair to others who did not apply, would
Yes,
not go. So merely because he loses out on employment, that's all right. You have taken advantage of it, but you have not thought of a bigger perspective of getting a more experienced hand, Mr. State. Anyway, you have not considered anything. It's only for other reason, for technical reasons that we are not allowing his case. Till you next.
Obliged.
daily list for hearing, item 5.
You got them.
May I please the option?
This is item.
La-
Yes.
Lana.
Yes.
My lord, in this case, my lord, there is some change circumstances.
Yes.
Initially, at the time when my lord, moved the writ petition, jurisdiction lies within the territorial jurisdiction of the Guwahati High Court.
Yes.
In the meantime, during the pendency of the writ petition, my lord, the regional office of KBS was shifted from Guwahati to my lord, Siliguri. As a result of which cause of action now at the moment lies within the jurisdiction of Calcutta High Court.
Withdraw this.
Therefore, my lord, I made a prayer before the court, but the lordship will, my lord, continue to hear the matter.
No, why should we?
Because of changed circumstances, because jurisdiction lies with Calcutta High Court at the moment. And Siliguri falls within the territorial jurisdiction of Calcutta High Court, and jurisdiction is, my lord,
Bank to is at Shiliguri.
No, so it is an order passed by, it's an order passed by bench of co-equal strength.
Yes,
This
ma'am.
bench only. But. we would ask him for the- Is this my request and the request? No. The request, like, we ignoring that. Leave it. Now we permit you to withdraw and file if necessary. Like, where is that order? I can find.
But at that, my lord, earlier.
What do you want? There is an order in your favor. We can hear it, but why do we hear it if there is other forum?
My lord, Lordship, my lord, it will be difficult for us to, my lord, to withdraw and approve the Calcutta High Court, file a fresh petition.
It's the same order.
It is my duty to point out, my lord, earlier, my lord, I raised this question and court was inclined to, my lord, hear the matter.
No, there is no question of inclination. We would always like the cases to be decided by the correct forum.
Right.
Go before the
Right.
Calcutta High Court and have your.
My lord.
Because as it is, you have a difficult case, no?
Because notification, my lord,
Sexual harassment and all that. Go
What?
before Calcutta High Court.
my lord, whether notification shall have any application, my lord, in the pending case.
Why
Because
not?
After the filing of the
That
petition, notification
depends
came
on the
before.
choice of the council.
My lord.
As on date, if you want it to be withdrawn, we permit you
My lord,
very freely.
Then in that situation, my
With
lord,
with a big note
My-
of thanks.
in that situation, my lord, I may be obliged. And if Lordship is kind enough to, my lord, give me at least 10 days time so that I can contact my client and giving proper instruction.
Mr. Vishwas, I have not been able to understand. Is Mr. Purkayastha. Mr. Purkayastha, I have not been able to understand what you want to convey and what you want to do.
Because my lord, Lordship,
You withdraw. If you don't have the instructions, you take time. You say, you tell the client that it would be better that the matter
yes,
is
that's why my lord, I
argued
need some time, my lord, to contact my client. And
as
inform him.
for on behalf of the, this is appeal or petition. As prayed for on behalf of the petitioner, we notify 10 days.
10 days.
5/8.
My lord.
I am representing KVS.
In this matter,
I am representing KVS respondent.
nothing. He needs, if he withdraws, no problem.
My lord, so far as me is concerned, I have no objection to, my lord, argue the matter.
But you can't blow hot and cold at the same time. Take a call. You are not offending us by saying that
Hello.
you want to withdraw.
Behind me, my
You are only obliging us.
client is standing behind me, my lord, that's why. Obliged.
Very, very courteous of you. Normally senior advocates do not question the territorial jurisdiction
My lord.
unless it is really required.
Right.
But we feel happier if you say that you don't have the jurisdiction. I want to take this case away.
Otherwise, my lord, Lordship may, my lord, at latter
All
point,
right,
Lordship
Mr.
may put a
Prakash, take
question,
your
my lord.
time, consult your client and withdraw.
My lord. Now, my lord, if he wants to do the case, I will do the case.
Then you have an order in your favor. We will hear you.
My lord.
Item 9.
Yes.
Rules are challenging. It'll take some time.
No, it's weird. Who responds in this petition? The union government.
Yes,
What do you have to say?
Lordship, insofar as the challenge to the rules is concerned, Lordship. He is challenging the rules which are.
He's not challenging the rules. He's saying
he
that the
wants
rules would require some incorporation of provisions which would make it, which will make it in consonance with the service jurisprudence.
Yes, Lordship. Now, from time to time, Lordship, in pursuance of the recommendations made by the pay commission, Lordship, changes have been brought in. And As it is, Lordship, they have entered.
They say that you're showing a stepbrotherly attitude for BRES. You have done it for
Lordship,
CPWD, you have done it for other departments, you have done it for others, but not for BRES. That's his concern.
Lordship, each.
Would you like to respond?
Each department.
Would you like to respond to it by an affidavit?
Lordship, that I can file an affidavit, but as
File an
it's
aff-
different ministries, different departments will have their own.
No,
Yes.
therefore he's not praying for, before us for changing his service rules. He's only seeking a direction to the concerned government to think, a rule-making body to think about it and carry out. Just respond so that we take a call. Let counter affidavit in the matter be filed positively by the next date. Re-notify so and so. 3 weeks.
3 weeks.
We give you 3 weeks.
Lordship.
18.8. Item 10.
May I please, your lordships? Item 10 and 12, my lord, they are similar, my lord.
10, 11 and 12.
10 and 12, my lord, not 11.
12, all right.
11
all right.
is coming between, my
All
lord.
right.
My lord, just basically, my lord, challenging, my lord, Rule 8(2), my lord, of the Provincialization Act 2017, my lord. Whereby, my lord,
Give us 2 minutes.
my lord.
This one. This one we have to read.
Page number, hey.
Education manual, page 117.
Uh, 99. Hmm? No, there's an issue.
You want to be governed by the pension rules of 96. Hmm. That would be big. Okay. Well, then what the problem is?
First type was.
Yeah. I will do next.
Chat services there. Yes, how do you substantiate your, how do you, on what principle do you base your claim? That is not a fresh appointment, therefore past services should be
My-
considered.
my-
The Rule 8(2) is absolutely clear, no?
My submission will be, my lord. Let's put the background, my lord, a little bit, my lord.
Background is not necessary here.
My lord.
You tell us the proposition of
My
law
lord,
that
yeah,
you're
what
conversing.
has
we'll-
happened,
we'll
what
deal
happens,
with
my
the
lord, in
facts.
this provincializations, my lord? The entire provincialization is based on past services. Because, my lord, these venture institutions, my lord, where these people serve, my lord, these venture institutions are, my lord, the service in these venture institutions, my lord, is the criteria for this provincialization.
Yes.
Without this, my lord, past services, these people could not have been, my lord, regularized and or provincialized, my lord. So therefore, my lord, on one part, my lord, these services are, my lord, the basic fundamental, my lord, to the,
This is what we wanted to hear from you. You're making sense to us.
my lord, fundamental, my lord, to this proposition, my lord, of, my lord, provincialization. And at the same time, they are saying, my lord, you'll be a fresh appointees will are governed by the fresh
So you
rules.
challenge you challenge.
Two, my lord,
8(2).
two, my lord. I rely upon some other provisions, well, I'll show, my lord, there are some contradictions also. My lord, 8(2), my lord. Terms and conditions of service, page 117, my lord, if we're carrying the same book, my lord.
Page.
It starts at page 99, my lord.
Just
19.
116.
117 is the relevance, my lord, section 8, my lord.
Yes.
My lord. Terms and conditions of service, my lord, 1 and 2, my lord. My lord, I'll read from my lord, 1 itself.
No, read 1 also.
My lord. Subject to the provisions of this act and the rules made hereunder, all rules including service rules and rules of conduct and discipline
which are applicable to state government servants of corresponding ranks shall be applicable to all teachers of educational
No, so we
institutions.
want to see that provision or see that, that part of decision where provincialization, I mean, considering the concept of provincialization, your past services, you have been provincialized.
My lord.
Where is that? I think there is a cutoff date for provincialization.
Provincially, yes, cutoff date is there.
There is a cutoff
Yes,
date,
madam,
and
that-
it has got
The-
nothing to
therefore,
do
my
with your, it has got nothing to do with your past service. You may have been working before NPS started. You may have been working since 2005.
True, my lord.
So therefore, the question which haunts you is
My lord.
that you would have little service left and therefore your pensionary benefit would not be so much,
My lord.
right?
My lord.
So whether that can be a ground for hitting
Understood.
the rule?
Well,
That's the question.
my lord.
I thought you were saying that this, the whole concept of provincialization is based on your past service.
My
No, this is only the cutoff date. That subtle distinction you'll have to understand.
Well, concept of provincialization based on past services, my lord.
Say this, I mean, now you're in the state service,
My lord.
right?
Now we are in the state service. Yes.
You're in the state service.
Yes, well.
Your very induction in the eighth service makes you fall under the category of people who would be governed by NPS.
My lord, that way, my lord, yes, my lord. But then, yeah, my lord, my
You
submission.
know the law that for hardship to few,
My lord.
the Article 226 cannot be invoked for hitting or challenging or quashing
My lord.
the rule.
My lord, I'll come.
Unless it is questioned on the grounds of competence.
Yes. That's it, my lord. I'll come to that, my lord. But my lord, my submission will lordship, may kindly look at the, my lord, I'll make my submission there. My lord, definition of employee, my lord, page, my lord, section 2H, my lord.
2H.
2H, my lord. Employees.
Yes.
Sorry, 2J, my lord. 2H was on the, my lord, what happened here? We were, my lord, regularized under 2011 Act. But the 11 Act got repealed in the meanwhile, my lord. Then, my lord, 2017 Act, my lord, came, my lord, there's some remedial measures were, my lord, taken, my lord. It will be 2J, my lord, sorry. 2H was within the earlier Act, my lord. 2J, my lord.
Yes.
My lord, 2J says, employee means and includes all serving teachers and tutors as the case may be of venture educational institutions who have been appointed and joined in the concerned venture educational institutions before 1st of January 2011 and whose services are being or would be provincialized under the Act. Now, my lord, provincialization, my lord, provincialized schools, my lord, has been defined, my lord, under, my lord, section 2Q. Provincialized schools or provincialized colleges mean existing provincialized college or colleges or venture educational institutions wherein the services of the tutors are provincialized under this Act. Now, the earlier Act, my lord, the system was a little different. Here, what has happened, my lord, these people are being, my lord, accommodated either in the same institution or, my lord, in some other institutions which are already provincialized. But on the earlier Act on which, my lord, we were provincialized, it was, my lord, the particular school concerned, along with the services of the teachers, my lord, who are eligible, they have been taken, my lord, and they are provincialized, my lord. Now, my lord, here, therefore, my lord, in the here, my lord, the provincialization has been defined, my lord, again, my lord, 2P, my lord.
Yes.
Provincialization means taking over the liabilities for payment of salaries, including dearness allowance, medical allowances, and such other allowances to the teachers and or tutors as admissible to the government servant of similar category, and gratuity, pension, leave, encashment, etc., as admissible under the existing rules to the government servants under the government of Assam. So, my lord, this, my lord, provincialization's, my lord, main motive, my lord, is to take over, my lord, the payment of the salaries, including, my lord, pension also, my lord. Now, my lord, under these Provincialization Act, my lord, though there is a cutoff date, my lord, that I should have been appointed prior to 1/1/2006, my lord, or the school must have come, my lord, prior to 1/1/2006, my lord. My lord, these people, my lord, this entire basis, my lord, is the past service, my lord. It is certainly not a new appointment, my lord. And my lord, these are the people, my lord, who have nurtured these institutions, my lord, at a stage where the state, my lord.
Now, please read 8.2 now.
8.2, my lord. Yes. The teachers whose services have been provincialized under this act shall get full scale of pay and such other emoluments as salary and allowances per the norms of the state government applicable to the government of the corresponding rank with effect from the date of provincialization of the services as if they are fresh appointees.
Just give a pause there
My lord.
and then read it again.
Yes, my lord. As if they are fresh appointees and they cannot claim any benefit whatsoever in respect of the past services rendered by them before provincialization. And in respect of pension, they shall be governed by the new provision pension scheme applicable to the state government teachers of the corresponding rank. That is what we are agreed with, my lord. We are challenging basically that, my lord, because, my lord, on the one hand, my lord, our basic entry into the service is based on that past service, my lord. And at the same time, they are denying our past service for the purpose of, but I can understand that let them not pay the money, my lord, but then at least that qualifying service should be taken into account, my lord, so that, my lord, they get some pension. Otherwise, my lord, most of these are not getting anything, my lord. Some of them are retiring, getting, my lord, 300 rupees, 400 rupees per month.
That can't be done.
My lord, this is one.
This cannot be struck down on that ground. Cannot be. They're limited. I mean, very limited.
My lord, but this is again, my lord, our legislation, which is, I would say, my lord, is similar, welfare legislation, my lord.
No.
Because my lord, this legislation is brought in, my lord, only to, my lord,
This is a service legislation.
True, my lord, true. But
I
then,
mean,
my lord,
whatever is your entitlement as a pensionary benefit, you get it without any if and but. But this is not welfare legislation. This
in the
is
sense, my lord, that these provincialized, these teachers, my lord, who were, my lord, imparting service to the state, my lord.
We agree with you
My
that
lord.
with this provincialization, suppose you are not provincialized,
My lord.
you don't have got the salary
No,
as
well,
much as you're getting.
true, my lord.
So you're getting something at one place which is being deducted in the other.
That is,
And there also, perhaps you not have even got pension. Unprovincialized,
The private school.
true, but once, my lord,
private school,
my lord,
and your services would have been absolutely temporary. The governing body of the school would have thrown you out
true, my
if you're
lord,
not very respectful to the principal.
true, my lord, true, my lord. But once, my lord, these,
This
my lord,
hardship is no ground. You know, that
once,
could be struck down only on the ground of competence or complete
true, my lord,
viability and workability.
my lord, my lord. But that is there, my lord, that limitation is there.
Both the cases arise out of similar issue.
Well, I'll just place one judgment of this honorable court,
Yes.
my lord, where, my lord, because of that, there are some similarities, my lord. But that has been, that is, my lord, annexed to, my lord, the petition itself, my lord, item number 8, my lord.
His name is M.
Where, my lord, well, this matter, my lord, was, my lord, decided by this, my lord, honorable court, my lord. It went to the apex court, my lord, then the SLP was also dismissed. My lord, this is, of course, with regard,
Which judgment are you referring to?
my lord, page 110 of the, my lord, paper, my lord, item number 8, my lord.
This is the.
Item number
Page, it
nine.
starts at page 110, my lord, extra 14. Item number 8, my lord.
Item number 9.
9, sorry, 10, item number 10.
Sorry, 10. 8. No,
The other way.
No, this,
no, this way.
huh?
100
It starts at 110, my lord. And extra 14. Read appeal number 145/2009, my lord.
Yes.
Well, this, of course, was with regard to, my lord, the provincialization of, my lord, the Panchayat Act, my lord, employees, my lord.
That you have said.
My lord.
That you have said in the beginning,
Right.
that they have considered it, but that cannot be a ground. No parity can be drawn.
My lord, they are also similarly situated persons, my lord, and more provincial, more or less similar, my lord, yeah.
Similarly situated would be a person in panchayat service who is
True,
who's
but the
not given.
provisions are more or less similar.
Yes, who appears for the other side.
This judgment was in regard.
Forget about this judgment. Tell us the judgment which says on what grounds can a rule be struck down? You're Mr. Mazumdar. We want to hear you.
Judgment on me right now.
What are the 5 essential grounds or the grounds on which a legislation could be struck down? You tell us 3.
The competence of the
Legislature
matter,
and
patent arbitrariness, my lord.
all right. Anyway, if I'm not remembering, why do I expect you to remember that? All right, yes, Mr.
Datta.
Datta, no? Mr. Datta. Take them. We have heard both the petitions together and are disposing them of by this common judgment. Mr. As a strike it off. Both the writ petitions are being disposed of by this common judgment. We have heard Shri M. Datta, learned advocate for the writ petitioners, and Mr. R. Mazumdar, learned advocate for the state. The issue involved in these two petitions are, the issues involved in these two petitions are that after the provincialization of the services of the writ petitions, they have been subjected to the terms and conditions which have been enumerated in the Assam Education bracket provincialization of services of teachers and reorganization of the educational institutions bracket close Act 2017, hereinafter referred to as Act of 2017, which provides that after the provincialization, the employees would be treated as fresh appointees who cannot claim any benefit whatsoever in respect of past services rendered by them before provincialization, and in respect of pension, they would be governed by the new pension scheme applicable to the state government teachers of the corresponding rank. It would only be apt to state here that the new pension scheme is applicable to the teachers, applicable to the state government teachers. The contention on behalf of the writ petitioners is that this term and condition of the service after provincialization is highly discriminatory, as it is not being enforced in other departments where provincialization has taken place. So that apart, the petitioners and similarly situated persons have rendered long years of service before provincialization, leaving with them only few years of service in future. And in case they are subjected to the new pension policy, which is contributory provident fund, which is contributory, perhaps the pensionable amount would be so meager as would make their lives difficult in the which would make their livings difficult in the evening of their lives. That apart, the argument advanced on behalf of the writ petitioners is that an employee has been defined under the Act of 2017, which includes all serving teachers and tutors of venture educational institutions who have been appointed and joined in the concerned venture educational institution before the first day of January 2011, and whose services are being or would be provincialized under the Act. Similarly, where is this provincialization?
2P, my lord.
2P, page 104.
And provincialization, provincialization under the Act of 2017 means taking over the liabilities for payment of salaries, including dearness allowance, medical allowances, and such other allowances to the teachers / tutors as admissible to the government servant of similar category, and gratuity, pension, leave encashment, etc. as admissible under the existing rules to the government servants serving under the government of Assam. It has been urged, therefore, that if provincialization of service means the shifting of the liability of payment of salaries, including pension, then perhaps the past services ought to have been counted for the legislation, which is primarily in the domain of service legislation, to have been welfare oriented. The concern of the petitioners is that even though Section 8(2) of the Act of 2017 talks about the shifting of the responsibility of payment of salaries and post-retirement dues. What have I said? Just one. Of the teachers who are provincialized, as if they are fresh appointees. But a correct interpretation would be that they are no fresh appointees, but fall in the category of government servant after provincialization. Both the grounds, namely of hardship and of interpreting whether provincialized employees are fresh employees or are freshly appointed employees, entitled for the counting of the services rendered by them in the past, do not appeal to us. The provision contained under the Act of 2017 with regard to terms and conditions of the service of government teachers, especially of those who were in venture educational organizations who have been provincialized, and which act has not been questioned on grounds of the competence of the state legislature to enact such piece of legislation. And there being nothing arbitrary in the act, the challenge to the constitutionality of Section 8(2) of the Act of 2017 is unwarranted and not sustainable. For the aforementioned reasons, we do not find any reason to entertain these two petitions, which are dismissed.
Obliged.
For hearing, item 15 to 20.
Hearing that, yeah, sure. 15 to 20. Yeah. 15 to 20.
Examination. My handing is now examination of having the tech qualification. My attempt to do that.
Yes.
Not very. Not very difficult.
Well, let the government start first, because I'm one of the appellants here. Being a private persons, the beneficiaries. The government has come against, another group has come against the same order of the learned single
This
judge.
appeal is by the state, no?
Sorry, it
One
is by
appeal is
state.
by the state.
So therefore he has the right to argue.
Yes.
And it will only be proper, but why are you suggesting this? He would argue, no?
No, they have come against, I am also agreed by one part of the judgment.
Oh, so have you filed an appeal?
Yes.
I have also filed it.
Okay.
But the government is,
Definitely, we will hear him first. Can I have your names, please? You are.
R. Mazumdar, my lord.
Yeah, we just saw you.
Well,
How about you?
KK Mahanta.
I heard you earlier.
Yes.
Mohantan, yes.
But this,
Take us to the judgment first.
that in the third paper book, Lordship would find the relevant portion would start from page 634. Paper book 3.
Item 17,
15, 15.
15, 18, third page.
Which is the third page.
186 of 2022.
Third paper.
Third paper book contains only the judgment.
Very convenient way of. Yes, the judgment begins from where?
634, my dear, the effective part. Prior to that is the name of the parties.
No. That numbering would not be there. Yeah, it's just the memo part. After the memo part, yes. Which part of it offends you and what is the issue?
What has happened is, my lord, for the purposes of recruitment of teachers in secondary level of the government schools, we have the concept of holding a test called the TET, the Teachers Eligibility Test, which was parameter to the TET being held for teachers for primary level students, which was a mandate under the mandate by the NCT, which comes under the Right to Education Act. Now, while conducting this TET, we found that the number of persons who were passing the examinations were not as many as the persons whom we were required to recruit. The variation was too much.
See, every state has got teachers eligibility test,
Yes.
screening test.
Yes.
That is just the eligibility.
Yes.
That doesn't ensure any appointment.
So, Malab, what we did was,
No,
further
no, first-
recruitment.
first Tell us, well, that's why do you have to take into account the concern that there are not many number of people? Because that would form the pool from where teachers would be recruited.
My lord.
Is that correct?
Yes,
So therefore,
that was
why were you worried that people were not
Lord,
passing the test?
when the number of posts which were vacant were in thousands.
And many, lesser
and
people were
the-
qualified in
The
test.
passing
Okay.
percentage was
Then what
somewhere around
happened?
hundreds.
Then you reduce the marks.
We did not reduce the marks. What we did was, per the act or per the rules, they had to pass in both the categories by taking 60 marks each.
And what are those categories?
Well,
Papers.
in 2 papers.
Okay.
And what we did was, in total, if a candidate had passed out but had failed to secure the required percentage in a particular paper, we gave a grace in that mark to make him pass in that particular paper.
Yes.
With the stipulation that those grace marks would not be taken into consideration when the recruitment process would be considered.
That's right.
So therefore, the number of persons who qualified came up. My lord.
There is a qualifying. They qualify, but every paper would have minimum of 40. Every vote will vote. And then, but that with the condition that that would not be taken into account. So that caveat was meaningless, no? That caveat was meaningless. That this award of grace marks would not be considered in the appointment process. Otherwise also it would not. So you just allow the person, who had failed because of not bringing requisite marks in both the papers.
Both the papers.
So you allow him to cross one barrier.
Yes,
But so far as recruitment is concerned, that's over.
but
That's only with respect to his basic minimum qualification of having passed TET.
in the recruitment
So what is this
process,
caveat that it shall not govern the
because in the recruitment process, we also take the marks obtained in the TET examination.
Okay.
So
You-
not to give him an advantage of that grace,
Oh.
to keep him on that level playing field, about it. Now, this was put up in challenge by the repetitioners,
Why?
saying that grace mark being given, people who were otherwise not qualified, who could not actually become eligible, were now being given the opportunity
So
of
therefore-
competing with them.
So therefore the pool was increased and we
Increased.
faced higher competition.
And those persons who had actually
No,
passed
but
the TET without grace,
But then didn't you give them some merit, kind of, there wasn't there selection with merit list,
yes,
whereby, say, a person had failed in the second paper, but
Yes.
because of the grace mark, would qualify in the examination as a
Yes.
whole. When taking the total marks, he became higher to them.
no, we deducted the grace marks. If he stood higher, even without the grace marks, he stood higher in merit. So that was put to challenge by the writ petition. Now, while disposing of the writ petitions, the learned single judge went on to held that this was parameteria to the TET being held for the LP school teachers, and therefore we could not have given that grace mark, number one. Number two, by giving the grace mark, when giving the grace mark, we could only take into consider, he also laid down how to give the grace mark, while saying on one hand that we could not give the grace mark, on the other hand, he says that this is how the grace marks are required to be given. Therefore, not only the writ petitioners are now aggrieved, the state is also aggrieved, and persons who were never there before this honorable court saying that we would also be eligible to participate have now become eligible to participate.
Could they give grace?
The entire thing,
That recruiting body, they can even cancel and. They do this. Let's see which what.
Sir, this is correct.
if lordship has page 678, where the,
1 second,
I'm sorry.
I've been pointed a paragraph by my brother. Yes, now there's the paragraph.
The directions of the learned single judge lordship would find it page 678.
No, you tell us the paragraph number.
That is 49 minus. Page, paragraph 49.
Page 678.
Is the page
678.
Also, I think this.
Yes. Yes,
The four sets of writ petitions are decided as follows. WPC numbers so and so.
where challenge has been made.
where challenge has been made against the grant of grace marks and prayer has been made for giving them preference over persons who were given grace marks are allowed. The award of grace to the extent of 5 marks in either paper 1 or paper 2 to candidates who have qualified in either of the two parts but failed in one is held to be illegal. The respondent authorities would do the needful to recall such grace marks within a period of 2 months from the service of certified copy of this order. However, the award of grace marks of 1 grace mark in respect of 2 questions is held to be fully justified and saved because the resource university has admitted error in answer to those 2 questions. In respect of the second set of writ petitions, the petitioners in the unreserved category who had otherwise scored minimum 60%, petitioners in the reserved category who had otherwise scored 55% in the aggregate and may not have secured 60% or 55% in any of the 2 parts are entitled to be declared as state qualified, which would be in consonance with Rule 10.2 of the 2018 rules, read with Clause 9 of the NCT guidelines dated since. Resultantly, the respondent authorities are directed to do the exercise of revisiting the mark sheet of all the candidates whose name or roll number did not appear in the TET results declared on 4/3/2020. And if any candidate is found to have otherwise scored the minimum percentile marks of 60% or 50%, all of such candidates are declared to be TET qualified in respect of examinations.
But tell us the reasoning. Where is the reasoning?
The reasons lordship would find from 645. I'm sorry. I'm sorry.
No, therefore it appears we are primarily concerned with the giving of, holding of the giving of grace marks to the
The
illegal.
TET qualified candidates. What our state's grievance is,
Others is all right. Wrong answer or whatever,
That is-
5%, 1 mark.
TET was never a part of the recruitment process itself. When the TET results were declared, the number of candidates who had qualified TET were declared, the grace marks were declared. At that point of time, there was no agitation by the petitioners. It is only when we proceeded
Give
with
us
the
the reason
recruitment.
why he says that grant of grace marks is a concession which ought not to have been given. Where has he said so? What is the discussion?
That is at 652,
Paragraph.
30. Mhm. The reasons and decisions start at page 649. Paragraph 25, reasons and decision.
Did you get it? Yeah, reasons and decision.
Reasons and decision, page 649, so on. That's all wrong. Paragraph 25. Hmm? Hmm. Hmm.
What are these 2018 rules in this regard?
That lordship should find in this. In December. Page 18 of the manual. 18 perhaps. And in your model. 18 it starts. And the TET part lordship will find it page 30. Okay, na? Okay. 1830. Rule 10. Rule 10, 2. Sub rule 2. That is at page 30 of the manual.
He has quoted it.
Regulations from repeated. That was wrong.
Yes.
My lord, here at the Lordship should have the page 649, where the grace marks have been discussed. Here, the learned single judge Lordship should find has referred to the NCTE norms.
NCT is something
So
very
that
different.
NC
no? It only says NCT does not talk of anything except NCT only says that a person who scores 60% or more in TET exam
Yes.
will be considered as TET pass. School management, government, local bodies, etc.
So
May consider giving concession to persons of SC, ST. That's not. Should give weightage to TET scores. That's all. 60%.
the first 60% part, which the NCT referred to, was only for the TET, which was mandated by the law for the LP schools, for the primary schools, not for the secondary school. The secondary school TET is totally governed by the 2018 rules. So a comparison to what the NCT had wanted, that every person who scored 60% in total should be declared qualified, may not be directly applicable to the.
That's
TET.
one aspect of the matter. We are talking about grace marks. You tell us
So that
what
is
does what does rule of 2018 say about
that
marks?
Lordship should find at page 30 of the manual.
That page. 30.
30.
Hmm.
10.2. In addition to such academic and professional qualifications mentioned in Schedule 3, for direct recruitment to the post, candidates shall have to appear and pass in the teacher's eligibility test in the concerned cadre
conducted by the government scoring a minimum of 60% marks in case of unreserved category candidates and minimum of 55% marks in case of scheduled caste, scheduled tribes and other backward classes and person with disabilities candidates. And here the rule says it is 60%. The advertisement said it has to be 60% in both the papers individually. Now, when people could not.
Where is that advertisement?
Advertisement, Lordship could find it in the first paper book. The page. 194 of paper book 1.
Read that part of the advertisement which says that one has to pass, one has to obtain 60% in both the papers.
Page 197, minimum qualifying marks for passing TET. To qualify in TET examination, the candidate must score at least 60% marks. However, 5% relaxation in marks would be given for candidates belonging to so-and-so. The candidate not receiving the minimum, I'm sorry, madam. Candidates have to qualify both the parts separately to qualify the examination. The rule did not say whether they had to qualify separately or as a whole. The advertisement issued says at page 197, just.
And when did you take that decision of granting grace marks?
Madam, that decision was taken.
Was that an oral observation or something else?
No, they filed notice to that. The file was moved. A proper decision, including the views of the honorable minister, was taken because of the lack of number of candidates. That in our affidavit in opposition at page 127, we have stated and records.
And the single judge says that no, it can't be done.
NCT does not say that it cannot be done.
Single judge says that it can't be done.
Yes, it's an.
NCT.
I'm sorry, madam, I misunderstood. I have but single judge says that it cannot be done. It has to be taken as a whole 60%. And therefore, persons who did not get the grace mark but yet got 60% were now declared to be qualified by the learned single judge who were never before this honorable court paying for such a value.
This is not. The only challenge that for it. What was the number? I mean, how did you quantify that your vacancy was what? I mean, there has to be some method to it, no?
Yes, madam. At page 120 of the, what we did was we gave it to the assessor to hold the TET. They gave us the number of candidates who qualify if no grace was given. Then we calculated as to how the grace would be given. We were given 4 choices, which were placed before the appropriate committee. And the appropriate committee said that the only thing that could be done is if they passed up in the total and they have less than 5 marks grace required, give 5 or less, so that individually they can clear the papers. Otherwise, these candidates had cleared the grace as a whole, the TET as a whole. That is at page 128.
How does this decision change the rule of the game? I don't think so.
Madam, persons who were declared not qualified in the
No,
TET.
perhaps you have not understood my question. We are questioning the logic of the learned single judge. This doesn't change the rule of the game, no.
It doesn't.
It doesn't, because it's for the benefit of all. I mean, all those who have failed, those who have got 60%, but less by 5% in one paper. 5 marks in one paper.
One paper.
So therefore, this relaxation to a recruiting body or to an examination taking body is permissible. It doesn't vary from the terms of the advertisement.
Doesn't.
Suppose if they advertise that this grace marks is given and later they say that no grace marks will be given.
Then it will be different.
Then it would be different. Or if they say that they have to secure pass and then nobody can question otherwise.
That is what I was trying to draw the.
Students would not have claimed for 5 grace marks.
Yes.
But if you decide, then
Give it.
perhaps it cannot be held to be discriminatory or anything, except that those who have passed on their own without the grace marks, they would find the competition to be tougher. That's all.
But when we take away the grace marks given, they again compete with people who scored less in the actual examination. That was one part. The
And
second,
in the examination, you would deduct that marks.
we would deduct the grace marks. We did not take the grace marks into consideration. That is one part.
The challenge did not come when we gave the grace marks.
Anyway, the number of debt qualified teachers
Yes.
you require is much more than who have qualified, correct?
Now, yes,
Vacancy is much more.
vacancies are much more.
And now what is the position now by your giving grace marks?
Yeah.
Has it come up to the mark?
We are still running with vacancies. The state.
Then what is the, why are they aggrieved, the other?
They are
persons?
actually because they sort of preference over those persons. What has happened is they scored less in the TET.
Huh.
They scored less in the TET, but other examinations, the persons who got grace marks might have scored higher, the graduate or the higher secondary level. So they get, in a total, they get more marks. The petitioners wanted these people out of the competition. And when we gave the grace marks, when the TET results were declared, more than 6 months before the advertisement, there was no challenge. Why were people allowed to pass with grades? It was only when we came to the recruitment part, then they came up to say that this TET part was wrong, which is not a part of the recruitment process. It's the thing dead and done. Only with the marks they now enter the petition.
So
So that's one part of the matter,
That is one thing.
which is under challenge. We'll hear you. Mr. Mahta, we'll hear you. You're for such candidates who did not require any grace marks.
Exactly. Exactly. So my grievance is that you could not have preferred some people who failed at the very first thing, could not qualify them.
How do you say that they have been preferred? How do you say that they have been given preference? They have been awarded grace marks. This is not recruitment.
Because of the grace mark, they have come to the pool.
That's right.
Otherwise, they were out.
How
That-
does it,
in that-
how does it change the rule of the game so far as you are concerned?
So far, my lord, that the question of holding that is concerned.
They
Must
don't
come to this.
see, they are not being permitted to steal march over you for the reason that these marks would be deducted. Grace marks would be deducted if the recruitment process is carried out.
My lord, that is one part. For the time being, lordship will consider the other part. First thing,
The difficulty is that
person.
we have, this has to be considered first before, considering the correctness of your argument.
My lord, I'm representing the candidates who are the beneficiary of grace mark. We have also preferred a
So
separate.
therefore, your and the
We
state
are
is just
selling
the same.
together, but I'll make my arguments, let my learned complete.
the question is, firstly, that you are holding a TET, eligibility test, qualifying test, who are qualified to apply for and participate in the process of recruitment. You are taking a pool first, choosing people that these are the people who are qualified to participate in the recruitment. And therefore, you have advertised, you have set the rules that look, every candidate must secure 60% mark in each paper of the two papers to be qualified in the TET. And with this intention, with this information to everybody, everybody participated. Now you are creating a pool first. Lordship is very right when Lordship first pointed out. Where comes the question of the number of vacancies to be filled up in future? Firstly, you are creating a pool, therefrom you will be allowing them to go to the recruitment process. And this pool can keep on increasing every day, every year holding that. It is not that.
It's better, Mr. Mohta, that you tell us what offends you in this judgment.
I am.
You have also challenged some part of the judgment. no?
Well, my grievance is the London single judge has said that 60% marks all right, you could not have given grace marks, but 60% as a whole of the 200, if of the 200 marks, if somebody has secured say 60% in one part, the another part he has secured less than 60, but combining both, if he has secured 120, then he is passed. Whether this interpretation is arbitrary or it is justified. This is your lordship is to consider.
This was not in the end. This was
But there was a between the rules and the
Have you not heard of situation where the examination taking body, suppose the High Court conducts a recruitment drive for class 3, class 4 post, and we set a benchmark, right? The vacancies are growing, burgeoning vacancy, the work of the court is stalled. And then we find that there are no candidates touching the threshold benchmarks. So we reduce it. This is not changing the game. This is permissible.
Well, in my school submission,
Otherwise, time, forget about the general recruitment process where there are hundreds and hundreds of people. Now you conduct a test for, people having shorthand, training. The benchmark, howsoever low you may keep, you will not find many people crossing that benchmark. And that is the difficulty why most of the positions in high courts or in other places with respect to stenos, the benchmark has to be reduced. This is not changing the game, rule of the game midway.
no, but the question is,
Now, if they would have said something more, I mean, the advertisement is absolutely clear. He has a candidate to obtain TT certification must get 60% in both the papers.
60% mark, and the
But
authority has
this
clarified.
what change they have brought about was on consideration of various factors, and the change was not irrational to the extent that it's only when 60% in aggregate a person has obtained, but is short by few marks, short of only 5 marks in one of the papers. Suppose this would have been possible only if you'd have got 70 marks in one and 55 in the other. So this is a category which should have been taken into account by any recruiting body.
Well, I have a slightly different opinion, I'm sorry.
Slightly, you have a slightly different opinion.
Malad,
Therefore, you're here in appeal.
yes, Malad. Well, the question is, here is a public employment. Everybody must get an equal opportunity. Isn't the case?
Your apprehension of others stealing march over you is absolutely unfounded.
No. Well, question of the whole process, legality, validity of the whole process, the approach of the government. Here. Kindly see the situation. They have conducted the TET with specific rules that everyone must secure 60% marks in each paper.
That's right. So grounds you have said, just list the grounds on which you challenge it.
Therefore, my response submission is the finding given by the learned single judge that the granting of grace mark was illegal and could not have been given. That is, to that extent, needs to be affirmed. Because it amounts to really, in my response submission,
that we have followed.
Changing
Now,
the rules of the case.
Since you have challenged some part
Then
of the judgment.
the other part, the interpretation given on the basis of the rule 10(2), kindly come to this again.
We want to. He says that it's aggregate of 120%. You are aggrieved by this part of the judgment which says that if a candidate has obtained 120, whatever marks he has obtained in each of the papers doesn't matter. He should pass.
Yes.
So this we have some reservations about the correctness of this because the court could not have done it. It has to be left in the hands of the recruiting body.
Malad, yes. That too,
And this calculation means nothing. So the standard which was thought of, the parameter which was considered for the state to give 5 grace marks under the condition when the candidate had already obtained 120 marks, with 5 marks only short, I think that is more rational. That's more logical. So
yeah.
this, we agree to that part also that 120, why should he have done? But then giving 5 grace marks, if he makes it 120, I mean, not 120, 5 grace marks and overall, yes, then it comes to 120 or more. So therefore, this is a very good, modality by which the marks could be, it could be, the balance could be struck.
My lord, there are two parts.
So we agree with one proposition of yours, that the single judge could not have asked for 120 category.
That interpretation,
We prima facie, we don't agree with it. Prima facie, we don't agree with it. But we disagree with you on this aspect of giving 5 grace marks, changing the game, the rule of the game.
then my lordship will allow me to make my submissions for few minutes. There are two parts. Firstly, recruitment process is there after the TAT process is over. That process first, recruitment
Has to
process
be, no,
next.
Has to be.
Has to. Now, in the TAT process, they have set the rules, and accordingly, they could have declared the results that this is the result. Those who have qualified. There could not have any discrimination, any injustice to anybody. No grievance could have been raised by anybody. If he has participated, not qualified as per rules, he's out. Many persons may not have joined because they were not at that time prepared to face it, because 60% marks would be wanted. Had it been the case there, well, some grace marks may be given. At that time, that notification would have been there, that condition could have been there. Probably matter would have been different. It was not there. And it cannot be also, because that is required to be conducted only to see that only the best candidates come to the pool in case of officers. That is the
minimum qualification should be there for consideration, not the best.
Minimum qualification.
Otherwise they would have made it, simultaneous, this would have been made synonymous with the recruitment.
Now
that's not there.
Now
the purpose of recruitment is to have the best.
Yes.
That process takes place later. So they are only setting up a minimum benchmark. This is nothing.
True, that minimum benchmark is with the aim to elevate the standard. They fix it. That at least the people with certain standard comes to it. That is the norm set by the NCT. That this is what is required now in the
NCT
schools and
not
colleges. Therefore, they have also said that TET is to be conducted. Otherwise, there was no TET earlier. Now, having said that, they could have allowed those people who have qualified in the TET to go for the next recruitment process. And the recruitment process, they would have said there can be consideration of granting or giving concession.
Mr. State, Mr. Mazumdar, has the recruitment process begun?
Recruitment process begun and
we are only talking about the urgency of the matter. If it is only at the stage of TET.
No, it is over.
TET is over, selection process is over. People have been appointed.
Yes.
My senior.
That is what.
Senior.
No, but what happened? I mean, this judgment.
It was stayed, my lord. We moved an appeal within a week and it was stayed within the week.
The honorable court was of the view that subject to final, there is an order, conditional order was there.
Oh, yes.
But this honorable court, conditional order, because they showed urgency that there is very many posts lying vacant, no appointment made, students are suffering. So court said that you may go for, but subject to the final result. The whole exercise was in my whole submission was wrong.
Mr. Mata, any one of your clients, failed in the recruitment process?
You're asking me?
Yes.
In the recruitment process?
Yes.
Recruitment, yes. Some of them were not.
Many.
Second. Because of these people, those who have got the grace mark. We were denied.
Some of them or all of them?
Mostly.
Some.
Of them. Not all, some of them.
You must have had a good day on TET examination. Not in the recruitment exam.
It my lord, depends. And obviously nowadays,
otherwise the whole process will be bad.
in our society, In Assam, as I find normally, mostly young people are after this post officers. Competition is the highest there.
Everywhere, not only in
Yes.
Assam,
So,
in Bihar also.
yes, therefore,
4,000 vacancies have been filled.
yes.
And we were very careful in not staying or halting the recruitment process.
And so,
Because that also offends the right to education. That also
yes,
offends,
yes, exactly.
elementary education
Yes.
rights of children.
So
Of course, we don't want any people non-deserving to come.
exactly.
Mr. Mohta, your clients are not deserving. Despite having passed TET, they could not qualify that examination.
No.
And they must have
And
been,
there will-
they must have performed very poorly for them to have failed completely.
Lord, even then, Lordship may appreciate many persons who may not have come out with first class get appointments in IAS, IPS, all that, and they perform well. And so also in other systems,
So
I need not have to.
Therefore, you are talking about the purity of the examination system. Here, the state
Therefore-
also considers it.
Therefore, my basic requirement nowadays is those qualifying tests. Those qualifying tests are very, very important. Merely securing 80%, 90% on merit may not result.
No system is fail-safe.
Therefore,
No system.
true, but we are experiencing trial and error method we are applying. And we are,
We are not agreeable to the logic.
therefore, my response submission is, well, my simple logic is this to my understanding. The chiefs will consider it. That whenever a qualifying test is held under certain parameters, those parameters could not have been diluted at the time of declaration of the result. When the result is to be declared, then they took into consideration how many vacancies will be filled up in future. Oh, there are 5,000 vacancies. And what is the result? 3,000. Well, we need another 2,000 people. All right, add marks and allow.
Mr. Mohta, are you suggesting that this expediency in the recruitment process should not have been taken into account? Is that your
That is, well, that exigency here, it is not an
expediency, I say.
Sorry?
Expediency.
Expediency could not have been there in the sense that because this is not a one-time performance. That is to be repeated every year. That is to be held every year or even twice in a year. Twice in a year.
This TET list, would it lapse in a year?
It remains for
2 years.
2 years.
So that's right.
Now it has become lifetime.
It has become lifetime.
Now
Don't you worry, the main examination is the main, the recruiting examination is the main examination.
No, they've changed the rules. No, they have changed the rules now. Because what happened, my lord? That is to be conducted every year at least once. And if they can conduct it more than once, well and good. Because every time people are being qualified, they are getting degrees and they will come and face the test and get themselves qualified to apply for recruitment process.
All right, anything else, Mr. Mohta?
Therefore, my full submission is that it amounts to interfering in the game when the game was already played and result was to be declared. Therefore, in my
The players had come out of the play field.
come out with.
Of the play field. So therefore it could not.
My lord, if I am not trained well, how can I wear the jersey to go to the field? I do not have a right to wear the jersey.
You don't have a right, but you have played. They have played and they have been successful.
The subsequent decision taken by the authority.
Formulate your points in 2 pages. Tell us. We are
Firstly-
fixing it for judgment.
Yes. Firstly, that.
Formulate your points, you can give it tomorrow.
Okay.
You can give it tomorrow.
Yes.
Yes, Mr. Chat.
Yes, Milord. Oh, Milord, there are 2-3 fundamental errors in the learned single judge's judgment, Milord. First of all, Milord, this passing of a TAT is a condition of recruitment. There can be no doubt about it. And it cannot be relaxed. Now, my lord, what relation does it have with the award of grace marks? Now, eventually everything boiled down to awarding of the grace mark, and that is a view which has eventually prevailed upon the learned single judge's ultimate conclusion.
Let me formulate it for you.
Yes, Milord.
this is a post decision,
Yes,
post the advertisement, post the examination. Therefore, it does not change the rule of the.
absolutely. Right. Well, even that is an aspect I don't think even calls for in this case, my lord. Now, another thing what Learned Single Judge has done, my lord, Learned Single Judge has taken the view, as far as, my lord, if your lordship should kindly come to page 887 of the judgment, impugned judgment.
You'll have to give the
Yes.
paragraph number.
Yes, I'll give, my lord, straight away I'll give. 8. In item number, okay, I'll give the paragraph, then it will tell you. Yes, my lord will kindly come to page number, paragraph 30 of the impugned judgment.
Or you can give the internal page number of the judgment.
Internal page number 175.
Yes, this is okay. 175.
Yes. It is not in dispute at the bar that all the candidates whose state result was declared on 4/3/20 had qualified without grace marks. Moreover, neither from the educational advertisement dated 13/11/19 nor from the subsequent advertisement dated 15/5/20, when the applications for re-evaluation was invited, it could be shown that decision of the government in the education secondary department to award grace mark to certain category of examinees was mentioned. In the matter of awarding of grace marks awarded to a large number of candidates, none of the parties in this series of writ petition, including secondary education department, have been able to refer to law, any law in force, including act, rules, or notifications by the central government, state government, or by NCT, whereby provision has been made for awarding grace marks to either a person or a class of person. 7, except when evaluation of answer script had been made basing on incorrect answer key, as was done in this case in respect of 2 questions, more fully referred herein before. So one of the view which Learned Single Judge has taken was, my lord, the state could not point out any statute or any notification which empowers granting of grace mark. Be that as it may, no material has been brought on record to show that decision to grant grace mark was taken before issuance of the educational advertisement dated 13/11/19. In reference to the aforesaid effect can be drawn from the fact that in the advertisement dated 13/11/19 and 15/5/20, it has not been specifically mentioned that grace marks up to 5 would be awarded to those candidates who have a shortfall of marks and below in any one part or 2 part of the same question paper. Well, I'll pause here for a moment, my lord. NCT guidelines, these are basically for elementary education. We are concerned with the recruitment to secondary education. Therefore, NCT regulation have no role to play here, my lord. Let us be very clear about.
No, even
Secondly,
even if it were to
yes,
play a role,
yes.
the wordings are, but that is
Absolutely.
grace marks is different.
Secondly, my lord, under the rules, that is Rule 10, there is no prescription of getting 60% marks in each of the papers. Supreme Court has said, my lord, anything which is prescribed in the advertisement, which is contrary to the
So
rules.
therefore, the only thing which the government has done is,
Yes.
Department of Education has done,
Yes,
that they allow 60%, but then overall 120 marks
Yes.
they must be having. I mean, but if it is short in one paper, 5 grace.
in fact, my lord,
That's one of the.
in fact, in the writ appellate proceedings, my lord, state
See,
had
the
filed.
difficulty, Mr. Mazumdar, is with you. Why this problem has arisen?
Yes.
You did not give it on affidavit.
Yes. No, it has been given. In appeal, it has been given.
Process, because the court says
Yes.
he has invoked section 114 illustration G. That there is no evidence to the effect that it was discussed, deliberated, the factors, the anchor is point, nothing has been done. That's the problem.
We gave it on affidavit that it was done after deliberations and records were produced. Somehow it escaped.
If your lordship would kindly have 738, my lord, page number.
Look at page 178
Yes,
of the judgment, internal page 178.
178. Yes, that presumption under section 114 has
So
been
therefore, the mindset is very clear. I did not read the first paragraph or the second paragraph, but this illustration G clearly reflects that the court was of the view that this is the statement.
Because there is no material.
A statement
Therefore,
of
don't
Mr.
produce.
Mazumdar, nothing more. Where is your affidavit?
In our exceptional question at paragraph 9, we had very clearly. stated
Yes,
that
yes, it
this
was
is
said.
How the process was done. The records were available, yes, not attached to the affidavit of position. is true.
In fact, my lord, at page, sorry.
Whether the person who has been doing great work actually.
That is the process.
সেটা affidavit বললো, আমাকে কইছিল।
No, you have not bungled in the matter, no. Somebody not having 120 has been given marks,
No, no.
5 marks.
No.
This is in our affidavit, we have very clearly stated, passed in one paper, short by 2 or 3 in the other.
Total. which is
Aggregate,
case mark is
aggregate.
120.
One person gets 70 in a paper.
70, 120, but he had, I mean, anybody getting 5 grace marks
Yes.
had obtained 120.
Yes,
Yes.
and
Without the grace mark.
yes, therefore we give the grace marks and we qualify both the papers.
That's a responsibility.
What the grievance of the petitioners actually was because one person scored 80.
The grievance of Mr. Mata is that his candidates have not passed.
Candidates passed, but
And this
When-
past that.
Passed, no, passed it, but they did not pass the recruitment
why
examination.
that happened was, person who we gave grace, one paper he had 80, in the other he had 59. The moment we made it 60, he comes to a total of 140. Now, the petitioner's case was they got 60 and 60 in each of the papers, so they come to a total of 120. We minus that one mark given grace, even then the grace mark candidate stands at 139. So some, I'm not sure for the other petitioners.
All right, you also formulate your points.
Yes.
Mr. Mata, you are giving it by tomorrow, then we fix it for judgment on Friday, otherwise next Monday.
After tomorrow, we'll submit it.
You give by the end of this week, we fix it for judgment on Tuesday next week. Yeah, I heard Mr.
I appear for those candidates.
Ah, please. You have 7 minutes.
Indranil Chaudhary. I Chaudhary.
In the
AG Arunachal.
I appear for respondents 817 to 821.
Yes.
I appear for those candidates who got the aggregate of 120. In one paper, maybe one got 72, but I did not get 55 in the other paper. So I got left out.
You fell out of the grace of the government.
And our simple case is the rules provide for aggregate of 120. By putting that additional criteria, we got left out in spite of what is provided in the rules. If your lordship has the rules.
Yes, it is very makes sense. Mr. Chaudhary. Yes.
If your lordship has a look at the rules, it does not speak of individual papers. It speaks of aggregate of 60%. Now here.
Which rule are you talking about?
Rule 10.2.
That's true. They are talking about advertisement, no?
No.
But the advertisement we made on the basis of this week.
এই election কিরকম করেছে?
The rules speak about an aggregate of 60%. Now, in the advertisement, you add that criteria that in each of the papers you have to have 60. And thereafter, when people don't get that, they fall short by 1 or 2 or 3 marks in one of the papers, you award them grace mark. Why? What is the magic in the figure 5? Why not 6?
No, I'll tell you the magic. Mr. Chaudhary will tell you the magic. We have been part of the recruiting exercise in another state. The logic is that we give grace marks, but without seriously impinging on the quality. Suppose Mr. Chaudhary is very good in constitutional law and average in criminal law, Mr. Chaudhary is a good advocate. But if you are very poor in civil law and only average in criminal law, you will not pass the threshold mark. So therefore, if you are short by more than 5 marks in one of the papers, even though you aggregated 60% in all, then perhaps your learning is lopsided. 5 is okay. There is no magic. There is no magic number. So there is no magic number in 17 that a person, or 18 or 21 that a person becomes adult. You find childish behavior even at the age of 40. Right? So therefore, this logic doesn't work. Your first argument was absolutely right. You have scored 120.
Not just 120, beyond that.
Beyond that. But failed in one paper or miserably bad in one paper. Otherwise, you will not go beyond 120. You have to have marks. You can't get 100 out of 100 in one paper. Right? Miserably bad in another paper.
Not.
So the grace marks also, grant of grace marks also has limitation. You have a good case. I mean, we are just trying to analyze what could be the process.
Your Lordship will kindly see, here is a situation where the rules, the Bible itself provides that this is how you will go about it. Because this is an eligibility test. We are all clear on that. It is just for the purpose of creating a pool. Now, while creating a pool, the rules say that if a person gets an aggregate of 60%, which is adds up to 120, he would be eligible. Now, you additional criteria that in each of the papers you have to have. In that case, you might as well stick to it, because a person, the moment a person crosses the threshold of 120, which means going by what has fallen from your Lordship, going by your Lordship's example. And the logic they apply. And this aspect has to be considered simultaneously with the ground on which they decided to award the grace mark. The ground was that there is such a huge number of vacancies that we would not mind awarding some grace marks to a group of people so that they become eligible. Now, here are candidates. The moment he has crossed that threshold of 120, borrowing your Lordship's words, he could not have been miserably bad. So,
For hearing, item 21.
Yes.
May I please your Lordship? This is an income tax appeal.
Yes.
Under
Against the judgment of ITAT.
Yes. There is a judgment of ITAT. And the issue involved is regarding interpretation of section 41(1) of the Income Tax Act 1961.
Yes.
My lord, in course of the last hearing,
The matter has been heard earlier.
This matter has been heard. And my lord, they were directed to file a report of the inspector, which was not here in the record.
Have they filed it?
They have filed, but they have not filed the complete report, my lord. There were two reports. They have filed only one report.
What is that report? The report with respect to, the notice to sundry creditors and their
Yes, my
statements. We need a complete record, no? Because that is the basis for the orders, subsequent orders reversing the decision of the commissioner and thereafter IT.
Yes, my
Is that correct?
Yes, that is correct.
So let's have the complete report, though I would not have called for it. We would not have called for it. We would have decided it on the issue which is there on the record. But then once it has been called for, you do it by next week.
Lots.
Complete the records by next week.
There were two reports. One was dated 9/11/2000.
By which
9/11/2017, my lord.
By which order it was asked for?
It is in the assessment order, that is at page 18 of the appeal memo.
27-2.
Mr. Counsel, can I have your name, please?
I'm
I always love to call the counsel by his name, not counsel. Huh?
Ramesh Goenka, my lord.
You are Mr. Ramesh Goenka.
Yes, my lord.
All right. Mr. Ramesh Goenka, you are a senior.
No.
Mr. Ramesh Goenka, learned advocate, submits that pursuant to the order dated 27/2/2025 passed by this court, asking the counsel for the asking the counsel for asking for a report of the inspector of taxes on which the tribunal had placed reliance, though has been filed, but the report is not complete. Mr. S.C. Kayal, learned advocate, submits that the complete report of the inspector of taxes shall be furnished by the next date. 2 weeks?
Lots. My lord, then thereafter we may file affidavit in opposition.
Give him something.
I'll supply it.
The report so filed, a copy of the report so filed shall be served upon Sri Goenka, who may file his reply in case it's needed.
Lots.
Re-notify after 2 weeks.
12-8. Item 24 and 25.
अपना तो 35. My name is D.K. Mishra.
Yes.
I'm senior advocate, and I'm appearing in item number 25.
You're appearing in item number 25, yes.
25, wherein, my lord, I have challenged the validity of some Central Motor Vehicles Act, Amendment, 11th Amendments Act 2020, and Central Motor Vehicles 17th Amendment 2021. That is my case. My learned friend has filed his case, my lord, was tagged with me. So he says his case will take 2 minutes.
He will take only 2 minutes.
No, my lord, I have not challenged the virus of the rules.
Yes.
I'm saying, my lord, the action of the state authority is wrong because it is against the rule itself.
Let's see.
Well, what had happened, supposing if any challan is pending, then what can be refused is, my lord, a license and registration.
No.
And not, my lord.
You have filed a PIL.
Oh, yes.
And you seek what relief?
Yes.
Let's see.
Yes. All that we are praying for is, my lord.
Motor vehicle rules.
No.
Act and rule.
Let's have the act.
No, a writ in the nature of mandamus. No, my lord, lordship will kindly come to. Please come to para 4, my lord.
Para 4 of what?
Number 4, prayer number 4 at page 27. A writ in the nature of mandamus should not be issued directing the state respondents to refrain from refusing to transfer and renew the registration certificate, driving license, fitness. Now we are on 2, my lord. This fitness and PUC, pollution under
I'm
control.
not on that page, Mr. Chaudhary.
Yes, yes.
Your
Page number 27 of PIL 52 of 24, my lord.
page number 27.
7. Prayer
Yes.
number 4.
Yes.
A writ in the nature of mandamus should not be issued, directing the state respondents to refrain from refusing to transfer and renew the registration certificate, driving license, fitness certificate, and pollution under control certificate. In fact, my lord, they presently were concerned with only, my lord, fitness and pollution under control. Because rule says.
This has been taken care of by
No, my lord. Regarding PUC, it has not been taken care of. Regarding fitness, it has been taken care of. Now, I'm relying on the
PUC
central.
also.
Yes.
Come to page 90. Para 7, page 90.
1 second. Lord. Yes. Neither enforcement nor traffic police or any other authority make any inquiry or investigation to find out as to who is responsible for violation of section 179 and 183 of the Act. It is very easy to find out the names and address of the registered owner from the vehicle register. No, my lord, Lordship need not go to this aspect. My lord, my perspective is very simple.
Page 91, it is there. The deponent begs to submit that it's true.
It's not true.
That is not true. That till such time such amount is paid, renewal of registration certificate, driving license, pollution under control certificate.
No, my lord, if my perspective is very simple. There was amendment of the rules, my lord. I'm just placing that amended rules,
Yes.
which does not impose any fetter. Please
No,
come
tell
to
me
pay.
one thing. That does not impose any fetter,
Ah.
but for the proper functioning of the rules. Now, unless you pay the penalty, why should it be renewed?
my
That's
lord.
the question.
No. The rule itself says if somebody does not pay the fine, then he is not entitled to XY, not XYZ. Now, what the state is purporting to do is they want to prevent everything.
Shows that part of the
Yes,
rules.
yes. Please come to me, Lord, page number 80.
Page number 80, yes.
Yes. Please come to sub rule 7. It's part of rules 167.
Just a minute, this is 11th amendment.
Yes, Milord. Milord, at page 79 is rule 167. And may I have your lordship's kind
one
attention
second,
to
sir.
page 80, sub rule 7.
1 second, 1 second.
If a challan, page 80, Milord. If a challan is due pending the time period specified in sub rule 5, except in cases of offences instituted for prosecution by a court, then applicants with respect to license of offender or registration of motor vehicle, as the case may be, mentioned in this challan shall not be processed by the licensing authority or the registering authority. So there is a bar on this. If challans are pending, then license of the offender and registration of motor vehicle, that will not be processed by the authority. Except application relating to permit, fitness or taxes of the motor vehicle. So what the authorities are doing, my lord, they are not renewing our pollution under control and fitness. Now regarding fitness, there was some deliberation and now it is clear. Now we are stuck with, my lord, this pollution under control. They are not doing it, my lord. And the government of India was directed time and again to clarify as to on what authority you were instructing the state government to do this and that. They could not come up with any convincing answer. That is the position, my lord. So according to the rule, in the case of pendency of any fine, then my license may not be renewed or my registration may not be renewed. Beyond that, they cannot say anything. But in fact, my lord, they are also putting fetter on the renewal of permit, fitness, taxes, etc. So we wanted direction from this honorable.
Just a minute. If a challan is due beyond the time period specified in sub rule 5, except in cases of offences instituted for prosecution by court, then the applicant
shall not be processed.
as the case may be, except applications relating to permit fitness taxes of motor vehicles.
We fall
That
in,
can be permitted.
yes, I'm on that marks, my lord.
So this is the rule says so.
So, but in spite of that, state is not doing.
Why? Who appears?
Then my lord, if I clarify.
Given by the central government. Phase 1.
Page 103, yes. What is NIC? Just a minute. PUC certificates cannot be granted for vehicles with pending tax. Traffic lights. No, read the 3 entirely. Read paragraph 3 entirely. No, difficulty, Mr. Chaudhary, is this, not that they have an option. They do it by way, I mean, they do it with the help of a software.
No, my lord,
The
yes.
software version does not permit it. Not that they have a choice.
No,
They are
no,
doing it
No,
deliberately.
my lord, I appreciate that. This
Yes.
is not in the context of putting any feather on the part of the state authority.
Yes,
It is something to do with the updating the software. My lord, my question is, when statute does not impose any,
No,
bar,
that's right. So you can say that there should be a direction to upgrade the software.
Precisely.
This is not stop.
yes.
This is one statement.
Yes.
That you make.
So
Yes,
we
but
say, my lord, this Roman 4 is in conflict with rule, sub rule 7 of
they
167.
don't intend to deviate from the central rule.
Yes.
That's not the question. Madam Counsel, you have to answer this.
Hmm.
This is no proscription.
Hmm.
You understand what proscription is? You answer the question first. You understand what proscription is? The central ministry is not preventing you from giving PUC certificates. They only say that it cannot be granted for the reason of the software which is being used. So this cannot be captured, and therefore we are not giving. So therefore, in essence, you ratify what he's saying. But you are required to update your software or make amends or make some provision whereby you don't stop that. That's the only thing. You don't. That's right. But he must have made Union of India as a party, no?
Yes, yes, we have made that.
That's what you're saying. Yes, what do you say?
Lordship is precisely correct on that. It is the software. Otherwise, Lordship,
Otherwise, why would you?
we have to go by the rules, Lordship. The rules is very clear. Lordship.
So therefore, what can you do to upgrade your software? I mean, you have to consider about citizens,
Yes,
no?
yes, yes, Lordship.
And then another day you will catch hold of the vehicle without a PUC certificate
And impose fine again.
and impose fine again and increase the burden on courts.
Lordship.
Find out and tell us what can be done.
Lordship.
Take down.
In the context of software application, therefore, মানে বার impose করবো কেন করো? হ্যাঁ।
By notification dated 25th of September 2020, issued by the Ministry of Road Transport and Highways, certain amendments have been made in the Central Motor Vehicles Rules 1989. One of such amendments indicates that if a challan is due beyond the time period specified in sub-rule 5, except in case of offences instituted for prosecution by a court, then applications with respect to license of offender or registration of motor vehicles, as the case may be, mentioned in the challan shall not be processed by the licensing authority or the registering authority, as the case may be, except applications relating to permit, fitness, and taxes of motor vehicles. In sum and substance, this amendment ensures that the traffic challan has to be complied with, and during the period when the challans remain pending compliance, there could be no registration of the vehicle mentioned in the challan or renewal of license of the offender. A motor vehicle to be plied on roads requires other certifications. One important certification being pollution control certificate. The contention on behalf of the petitioner is that during the pendency of the challans, pendency of the compliance of challans, even the pollution certificates are not being granted. It appears that the software developed by the NIC does not capture the PUC certification. Precisely for this reason, it has been clarified in the notification dated 9th of May 2024, issued by the Government of India, Ministry of Road Transport and Highways, bracket MVL section, that PUC certificates cannot be granted for vehicles with pending traffic fines. The states and the union territories have been requested by the central government to implement the updated PUCC software with version 2.0 of the NIC at the earliest, in letter and spirit. The rules, the amended rules does not, next paragraph, the amended rules does not prescribe issuance of PUC certificate during the pendency of the challan compliance. The state transport department also does not intend to do so, but is not issuing PUC pollution control certificate for the reason of the deficiency in the software within which such processes have to be complied with. The Learned Counsel for the Union of India submits that he shall communicate with the responsible officer, with a responsible authority, with the responsible functionary of the transport department for upgradation of the software, so that even during the pendency of the traffic challan compliance, pollution certificates are issued. The learned counsel. आपका नाम क्या है? What is your name?
I'm R.K. Dikshit, Your Lordship.
Mr. R.K. Dikshit लिखना ऊपर में. Mr. R.K. Dikshit, learned counsel for the union of India. Mr. Dikshit submits that he shall get back to the spot.
Chaudhary.
No, that PAT. Take the name. Submits that he shall get back to the spot after receiving communication in that regard from the central government. Re-notify 3 weeks.
Keep level.
He was right. Your friend was right. You took only 2 minutes.
Now I'm leaving the field for my learned friend.
Yes.
Aye. May I repeat, Your Lordship?
Yes.
My lord, at the outset,
Yes, Mr. Mishra.
at the outset, my lord, I'll be little slow. I will be no match with the pace that Your Lordship is
No.
going on. I'll be little slow,
Please don't hurry up. Stay at your own pace,
my lord.
but don't get disturbed by my repeated questioning.
No,
That's
no,
my way of working.
that
I
I
understand.
will not. I'm saying because of the health reason.
No. You can take your seat and argue.
No, I'll do that. My lord, if Your Lordship will take up the paper book,
Yes.
the writ petition, I'll request Your Lordships to just look at the short synopsis that I have given. That is my total case.
You're referring to list of dates.
No, it's synopsis. It's synopsis. It's like it starts public interest litigation 46 of 20 starts with that.
See, I'll take some time to navigate through your files. The reason is that this is not, there's
My lord.
so many loose papers here. We had in Patna High Court a spiral binding and a convenience volume. Very easy. No, thick volumes are kept by the side only for confirmation, and convenience volume with a spiral binding. So pages don't turn like this.
Yeah, I also
It's very
do that.
well organized.
But this
It
is a
is done
short
very
matter.
well. But then
I do that. This is a short matter, so I just have compilation of the judgments. Yes, please. If Your Lordship permits me, I'll please. The Central Motor Vehicles 11th Amendment Rules 2020 and the Central Motor Vehicles 17th Amendment Rules 2021, as well as the Standard Operating Procedure dated 17/12/2018, on the strength of which the police/enforcement officers are compelling the registered owner of the motor vehicle to pay the penalty for alleged violation of the Motor Vehicles Act without any adjudication or order from the court, are under challenge in this instant PIL on the following grounds. Rule 167(5) of the Amendment Rules of 2020. This is the 11th Amendment Rules, which I'm calling it Amendment Rule of 2020. Provides for disposal of challan within 90 days from the date of its issues. And 167 provides that if challans are not disposed of within 90 days, the license of the offender and the registration of the vehicle mentioned in the challan shall not be proceeded by the authority. If Your Lordship permit me, just I take a pause and say, this disposal of outer limit of disposal of challan is by whom? Has to be by the court, where the challan will be filed.
let's see 167(5).
Well, I have annexed that at page 52. The notification is annexed. The relevant is at page 53 of the paper book. Same writ petition only. Yeah. PIL 52 is in the Hindi version, and the English version is at page 53. 53. The relevant rule my lords will get at page, starts with page 55, 167, and if Your Lordship turn to page 56, 56(5), challans under these subrules 1 and 2 shall be disposed of within 90 days from the date of issuance of challan, in physical or electronic form, except in cases where offense instituted for prosecution by a court
Now, there is a catch here in this rule.
Hmm.
The police never sends it to the magistrate. It never sends the case to the magistrate, or they send it, there will be a selected case. There will be selected cases which they will send. And one will compel to be filed, because after 90 days, if he cannot, nothing will be given. Even his driving license will not be renewed, even RC will not be renewed.
Shows the provision which permits the police to send traffic challans.
Send?
To issue traffic challans.
No, there is no provision for sending here. Your lordship will see from 167 at page 55. That's how they don't say my total case is that. And the basic case is that. If they send it to the magistrate, perhaps things will be taken care of. But they don't do it. And not only that, I have to prove my innocence before the police in the police station.
Page 355 is the rule 167.
Page
355.
Where is the forum for challenging such issues?
No,
You can deny
no
it.
forum. That is how I'm before your lordship. I cannot go. And everyone, all of us have suffered, including my lord, myself. There two challenge. Well, I don't drive vehicle myself. They made me accused in both the cases. In one, they sent to the magistrate. There, my lord, threw something. It was
Unless, I mean, if the
other one, they have not
if
said.
the offense is of such a nature, what are the offenses, penalties in this? Chapter 8 of the rules of 1989 deals with the offenses, penalties.
My lord, section 208, if your lordship will see, the act.
Of the act.
Act. It is, the power lies in the magistrate. Otherwise, also your lordship knows. The police can't hold me guilty. The bulldozer case, recent bulldozer case, my lord. Because the police or executive cannot hold any person guilty. It has to be judicially empowered person. Page 208, if my lord will kindly see. Summary disposal of cases. Section 208.
No. Now, Mr. Mishra,
My lord.
you're well, no?
No, I'm well.
Okay.
It's continuing, my lord. I was accommodated by all the honorable chief justices.
So
That's why-
therefore I would require you, I mean, I would feel good if you sit and argue. I have no problem.
No.
Whenever, in fact, I always, in my parent high court, I knew which senior was how many years old.
My lord.
So anybody above 75 years, I used to offer on my own. Mr. Swanshaw, please take your seat.
My lord.
Some of the elderly advocates used to say that no, our mind doesn't work if we sit down. We can only think on our feet. That's the reason. I mean,
My lord, though I'm 72, but this.
you are
because of this.
72, that's no age.
Well,
That's no age for today.
That's
Yes, now
Now, this year I'll be completing 49 years of practice. Next year, 50 years, and then perhaps I'll hang my boots with this health condition.
No. God willing, you shall continue. Now, let's see. Now, come to 164 of the rules.
Mine.
Come to the heading.
My lord,
You will have, if the compilation is the same, universal, then you have it at page 354.
no, my lord,
The rules.
Rules.
Yes. Okay, yes, my lord, 164. Yeah, this, yes,
Page 354.
yes,
Offenses for the purpose of section 208,
yes,
right?
that's right.
So these are the offenses for which challans are issued.
My lord, except, your
Are
lordship-
is there any other provision where
Yes.
challans are issued not for the purposes of summary
My lord-
proceedings?
No, my lord, your lordship will see 208, section 208 of the Motor Vehicles Act. Motor Vehicles Act. The court taking cognizance of any offense other than, this is what your lordship has said, other than the offenses which the central government may by rule specify in this behalf under this section. This is 164 which your lordship. Now your lordship will come to subsection 2. Where the offense dealt with in accordance with subsection 1 is an offense specified by the central government by rules for the purpose of subsection, of this subsection. The court shall, if the accused pleads guilty to the charge and forward his driving license to the court with a letter containing his plea, make an endorsement of such conviction on his driving license. My lord, the basic principle of rule of law
No, that
should
we
be aware
Mr.
that
Mishra,
they cannot hold me guilty.
you need not labor on that.
Man.
I was only thinking that these are the only offenses which have been identified, traffic violation.
No, my lord, the others.
Others are all.
True.
Now, where is that provision where this summary proceeding would not be applicable?
My lord, summary proceeding.
Now,
with
let's
a-
see the rules. You can very well challenge those parts.
Yes,
So the offenses for the purposes of 208,
yes,
right? So
Yes.
if the challan has been issued for these offenses,
yes,
then 208 gets skipped.
yes. Now, your lordship, I'll straightway take your lordship, the challan which I have given as illustration,
Yes.
where the punishment of fine, the fine rather is imposed by the police
Yes.
under 179 of the Motor Vehicles Act, 179 and 183. I can't get it. 179,
Yes.
then 183. Driving at excessive speed. Now, these are not covered by this will not be covered by 164. By 164.
That's what I'm driving
Yes,
at. No?
yes, my lord.
That's what I'm driving at. So
My lord.
therefore, these are the observations of the police for which no evidence can be given.
Well,
for which no evidence can be given. But think of this situation, Mr. Mishra,
My lord.
that the police says that you have jumped the red light.
Yes,
You say that no, I have not jumped the red light.
yes,
And nowhere in the world
yes,
can there be a summary proceeding for this to say what will be the evidence.
yes. My lord,
So therefore, these are the offences
But
which, I mean, the rule-making body, the act-making body, they contemplated of this situation. And 208 is for limited instances of the offences,
my lord,
which is not, which is limited. So therefore, once, like you showed, I mean, 179, 183,
yes,
these are offences which are, I mean, which would lead to fines only.
yes, yes.
And if you say that these fines, these imposition of fines also, if it is not decided by a court, then it is beyond, I mean, then there is no separation of executive or the police from the judiciary.
Yes.
Would that not be stretching too much?
No, I'm not. Because if your lordship will see section 208, subsection 2, which I've just placed. Even if the offences which has been dealt with, provided that where the offences dealt with in accordance with subsection 1 is an offence specified by the central government. These are the offences which have been specified by the central government. By rules for the purpose of this subsection, the court shall, it's not that they will not be sent to the court. The court shall, if the accused person pleads guilty to the charge and forward his driving license to the court.
That's all right, sir. That's what I'm saying, no?
So therefore,
probably I have not communicated myself to you.
Maybe I have not understood.
No. For 208 to be applicable,
yes,
the offences must fall in the category of the offences enumerated under 164. So far, so good.
Yes.
So far, so good.
Yes.
Now we read section 20, which is a 208 subclause 2.
Yes.
What does it say?
Yes.
Where the offence dealt with in accordance with subsection 1.
Yes.
Subsection 1 is, may the offence is an offence punishable with imprisonment under this act. It's not fine. Or shall in any other case state upon the summons to be served to the accused persons that he may appear or plead or anything. Shall in any other case. I mean, this is where it is punishable with imprisonment, definitely.
My lord.
It has to have the final verdict by a court of law and not merely the police deciding to fix the quantum of fine. And that also is not unchannelized.
My lord, if I have understood correctly, my lord, the provision subject to what your lordship.
No, please correct, sir,
your lordship lay down the law.
I am not particularly deft at transport, though I have dealt with certain amendments. I have stayed the operation of certain amendments.
My lord, here there is no specialty because the cases are such nobody can afford to be specializing like other big high courts. My lord, there are specialists.
Yes.
We are jack of all.
You have specialist advocates in Patna High Court.
Yes.
Only for motor vehicles.
That's right.
Huge number of cases.
My lord.
Especially against tribunals, motor vehicles accident tribunals.
My lord.
Yes.
My lord, what I'm just saying is 200 section 208 subsection 1 provides the court taking cognizance of any offense other than offense which central government may by rule specify in this behalf. Now, central government has specified, your lordship has pointed out, 164. Now, subsection 2 deals with this exception. The exception is where the offense dealt with in accordance with subsection 1 is an offense specified by the central government by rules. Here they have done under 164. For the purpose of this section, the court shall, if the accused pleads guilty. So, my lord, with all respect, the court cannot be substituted by the executive. The cost of repetition, I'm saying this.
I don't read it this way. Some of the other, I don't read it this way. Maybe I'm wrong, but no, I don't read it this way.
My lord. Because if your lordship will see.
Just a minute. Now, the court taking cognizance of any offense other than an offense which the central government may by rules specify in this behalf.
So this
So
there
the
is,
cognizance of an offense
Yes.
other than one specified.
absolute,
Okay.
right,
So
right.
this specification is not referable to 164 to 164. That is something else.
My lord, if your lordship will see,
That is something else, sir.
my lord, kindly see, 164, maybe I am not able to communicate, my lord, 164 rule, which your lordship has pointed out. 164 says, offenses for the purpose of section 208. The offenses for the purpose of subsection 1 of section 208 shall. Then these are the categories which are mentioned, sections are mentioned. So these are the sections which have been specified by the central government under 208. And for this subsection 2,
for this court proceeding is necessary.
yes.
This is for,
No.
this is not,
Court proceeding is necessary for all. Because if your lordship, let me place the entire 2008, 208. Let me place the entire. The court taking cognizance of an offense. I'm placing 208, my lord. The court taking cognizance of any offense other than an offense which the central government may by rule specify in this behalf.
so this, what
Under
is,
this,
this is referable to what offenses?
I'm going down. Can you see? May, if the offense is an offense punishable with imprisonment under this act, and shall in other cases state upon summon, this is of the court, summon to be served to on the accused person that he may appear by pleader or in person, may by a specified date prior to the hearing of the charge, plead guilty to the charge and remit to the court the money order, such sum not exceeding the maximum fine that may be imposed for the offense as the court may specify. And the plea of guilt indicated in the money order coupon itself, provided that the court shall, in the case of any offenses referred to under subsection 2, state, this is subsection 2, this will apply to these rules. State upon summon that the accused, if he pleads guilty, shall so plead in the manner specified in clause B, and shall forward driving license to the court with his letter containing such plea. Well, with all respect, there is no.
So therefore, the summary disposal of cases.
Yes.
This goes before a magistrate,
Yes.
right?
Yes.
So when you receive a challan,
Yes. Yes, my lord.
that's an indication to you to either pay or you go to court.
My lord, unless they send the challan to the court, because I have tried that.
No.
They
I
say
think-
we
I think
we don't know.
We are missing out on that proposal. Challan, a copy of challan. Otherwise, what is the purpose of
I'll-
electronic court proceedings?
My lord, absolutely. That's why I was surprised and while challenging this, reading these provisions.
Yes.
I'll just tell your lordship the modus. CCTV cameras, CCTV and cameras are installed at different places. A vehicle is parked, say in non-parking zone. The camera takes the photograph of the vehicle, the number comes. Now, the moment the photograph goes to the police station or the enforcement officer, they prepare a challan, they quantify the fine. Your lordship will see the fines are on a scale. They put maximum. Because the police cannot be expected, my lord, to give on a scale.
We are absolutely, I was slightly baffled by this. Now, a challan, are you suggesting that the payment of challan within 90 days
Yes.
is to the police? No, it is to the court.
No, then there is no quarrel.
Yes.
That's why your lordship will be surprised.
How is that possible? Otherwise, all these electronic, upgradation of courts, we are doing virtual courts only for these traffic challans.
Yes, and because there is a virtual court.
That's right. But why do you say that it cannot go to court? The challan to you,
Yes.
just a minute. A challan to you also goes, a copy of it goes to the court. Yes, it does.
That's why I think, and with all respect, no. If it goes, I can go to the court. So in one case, my lord.
Now, tell us what is the position? Now, we are not disputing Mr. Mishra, but I don't believe it to be correct. It has to go to court.
Perhaps.
Where do you pay? You don't pay in police station.
Yeah, it has to be paid online.
Online, but it is processed by the court.
Nothing.
No.
My lord, I'm saying that your lordship will not.
Yeah, unless if you accept that challan, take it, deposit the money. If you don't, file a case.
Absolutely, that is my case.
So you go before the magistrate. 90 days is good enough time for you to challenge it.
My lord, but magistrate, we go there. In fact, in my case, I said, I didn't come to the court. I sent my juniors. They went. We filed an application that such and such challan we have received. It is uploaded on WhatsApp of the registered owner. So where is the case? We want to contest. We cannot do anything unless the challan comes.
No, challan shall come, no?
No. If it comes, I have no quarrel. That is my case.
Tell us about the system here. It has to come to court.
Perhaps, lordship.
All traffic, we have so many courts. It's all virtual. They accept.
Lordship, the facts that the experiences of my senior, I've also gone through. Therefore, I know. I have been issued a challan. I know. Now, what happens is, lordship, as it has been followed here in the state of Assam, there is a period of 90 days by which one can pay online. If it is not paid or settled within the period of 90 days, then summons are issued by the court of the magistrate. There is a regular court of a magistrate sitting here, and on a particular day, those cases are taken.
Here now this is the practice. I mean, I have never got any challan in my life, therefore I did not. So if he doesn't challenge it and pays within 90 days, no need to send it to the court.
No.
Otherwise, if he doesn't pay, then only it goes to court.
Yes. Then summon is issued. He cannot contest his claim there, lordship.
No, he says that why do I wait for 90 days?
Then he can challenge it before.
Where?
He can challenge it has to be before the magistrate.
My lord, if what he says, your lordship will record his submission.
It has to be before the magistrate's court.
When they upload this in my WhatsApp, in the registered owner WhatsApp, they'll have to send it to the court. And inform.
What is your name?
I'm R.K. Dev Chaudhary, lordship.
Dev Chaudhary.
Mr. Dev Chaudhary. I'm sorry, I'm
that's
forgetting him. Mr. Dev Chaudhary. You just find out from a magistrate's court, magistrate's court, what is the procedure, and you ask for, the traffic department, traffic police, SP traffic. You're a government council, no?
Lordship, the state council can do that, lordship.
State council. Tell him what I am wanting.
Yes.
Tell him what the court is wanting. Just tell us the procedure.
Yes, lordship.
Tell us the procedure, because if it is not there and it is happening as Mr. Mishra is telling, then perhaps something has to be done. Please find out.
Yes.
Have you understood what the court wants? You have to go to a court which deals with these challans, and you have to know the procedure. Number one. Number two, you have to talk to a senior officer in the transport department, senior police officer. What is the methodology? How do they do it? The moment they issue a challan to a person, to the offender, they send a copy to the court. And these softwares, they speak to each other by the same mechanism, by the same, what is it? By the same, the version, the app. No, it's the same app by which it is sent to the magistrate's court. I think it is contemporaneous. Sir, can I tell you one thing? This digitization thing, it first began with the transport or traffic.
Yes.
Right?
Yes.
In many states of this country, all FIRs, once it is registered, it is immediately uploaded.
Yes.
And it also goes on NGDJ or some apps where it is available.
Yes.
So this has to be contemporaneous, and therefore this 90 days is for the period for you to decide whether you will comply with this or pay, or you will challenge it there.
Yes. My lord, let me, just for clarification, there are two more rules, two lines, if your lordship. permit me.
Can we await, what is your name? Mr. P? Saikia. You find out, please talk to Mr. Dev Chaudhary, confirm it, and then we'll hear it on the next date. Mr. Mishra, we'll hear it on the next date. Let us first be very clear about the procedure which is being followed. All right?
My lord, one more thing he can. The challan goes to the court. The outer limit for disposal, the outer limit for the trial, suppose I don't plead guilty. The outer limit is 90 days. Then that means they are fixing outer limit for punishing me.
No, you can't say it like that, no. If you don't grant any outer limit, they may continue it forever.
No, not that.
I mean, and you can't restrict it for lesser than 90 days because it will be unreasonable.
This is for payment. It's payment.
Payment because you will not, if you don't activate yourself, if you keep sitting for 90 days with a traffic challan in your hand, then 90 days.
My lord, that never happens. We go there.
And even otherwise,
Yes.
even otherwise, after 90 days, if you don't pay, then even if the challans have not been sent to court contemporaneously, they will send it now.
That's why I'm saying whether the rule can give. That's why they have challenged the rules.
Just find out.
That's
the
how
rules and-
challenge the rules.
What is the procedure? Tell us. We keep
Well,
it next week. It's very interesting to know. I mean, how does it work? That way. Challans, I think, are contemporaneous.
It is being done by the CGM's court here.
Yes.
You find out, just don't have a helicopter view of it. Go see, sit in the court for some time. It will help you, it will help us. Now, as a friend of the court, you go and find out. And Mr. Dev Chaudhary, you also.
Yes, Lordship.
All right, Mr. Mishra, we'll hear you on that.
My lord, if your lordship can take it on.
No challans can be issued for offences enumerated under 208. No challans.
My lord.
Challans are only for the offences which are not enumerated there. Otherwise, it goes to court straight away. These challans, they give you an option. Trust the police's version, pay, get rid of it.
Yeah.
If you want to challenge that also, go to court within 90 days. If you don't activate yourself, you don't push yourself, don't pay. Otherwise, also they'll send it to the court.
My lord.
So therefore, the institution of adjudicate, I mean, the police does not remain the adjudicatory body. It is for you to choose. Suppose it is for you to choose. Either pay.
I was only thinking, my lord. Your lordship will remember there were two cases, common cause cases and Rajdev Sharma case.
Yes.
Where outer limit, 2 years, the prosecution is pending, discharge the accused.
That is something different.
Then P.
Rajdev Sharma, you are talking about one.
State of
Rajdev
Bihar.
Sharma 3.
Three, yes.
Rajdev Sharma 3, they have changed.
Correct, my lord. Thereafter, my lord.
That outer limit has been extended. It has been made fluid.
Yeah. Now, P. Ramarao, my lord, overruled these two.
Yes.
Rajdev.
Yes. So this is not the offense of that kind, sir. No, that was offense against, those are higher offenses.
No.
Petty offenses.
No, any
Therefore,
punishable with less than 3 years. Of course, not someone only, not someone case.
this does not even say that. These are offenses which requires punishment without anything. 1 month, 2 months. Fine.
My lord, if I'm only saying, if they are sending it, we have, because we go there, we are not given. I've said, if they send us in the challan copy, only if they write copy, because your lordship will kindly just see 1 minute, my lord, because there cannot be any embargo of 90 days in respect of those where the challan goes to the magistrate, my lord. Your lordship will kindly see. Five again, if your lordship can read at page 56, my lord. Rule 5. 167, 5. 167, 5. Your lordship will see challans issued.
Yes, what are you referring to?
If we are holding, we are holding the same book, page 355.
Yes.
167.5. Challans issued under sub-rule 1 or 2 shall be disposed of within 90 days from the date of issuance of challan in physical or electronic form. Kindly see the exception. Except in cases of offences instituted for prosecution by a court. And in fact, in one of my cases, they did not do anything. I went and I paid some fine. The driver went and paid, my lord. So cases where they have sent it to the court and that they don't, that embargo of 90 days doesn't apply.
That's all right. The section remains the same even in the amendment. 167.5 reads the same. Here in the 11th amendment that you have referred to, it says challans issued under sub-rule 1 or 2 shall be disposed of within 90 days from the date of issuance of challan in physical or electronic form. This makes it even more clear. This makes it even more clear that this is with respect to under sub-rule 1 and 2.
Yes.
Sub-rule 1 and 2 is police officer in uniform or any other challan facility physical to a person.
Yes.
Who is same by a designated authority, electronic monitoring. So this goes for compliance and it has to be disposed of within 90 days, except in cases of offences instituted for prosecution by a court. So this read with the other rules, they make it very clear that 90 days is the outer limit. Even for, and that outer limit is not for the offences for which the court proceeding is triggered. It is in case of offences instituted for prosecution by a court. So what they say is 90 days for you to pay the challan.
Let them have this clarification because when the
now, Mr. Dev Chaudhary, I mean, I'm not very sure about your proposition or your suggestion or your experience that after 90 days, if he doesn't pay, what happens is that the matter is sent to court. No, then it is for prosecution.
I am
find out and tell us.
Yes, I'm telling that from my experience, Lordship. It has what has come out is after 90 days, the summons are issued by the court.
The summons are, even if found out it is received, never issued.
Heard Mr. D.K. Mishra.
It's a pleaded case.
D.K. Mishra learned senior, but heard Mr. D.K. Mishra learned senior advocate for the petitioner and Mr. R.K. Dev Chaudhary for the Union of India. The Transport Department of the State of Assam is represented by MS? MG Bora. In the present petition, Mr. Mishra has laid challenge to the system of disposal of traffic challans, especially of setting an outer limit of 90 days.
Others also are there.
Setting off 90 days for the disposal of such challans. In order to understand, in order to properly appreciate the contentions raised on behalf of the petitioner, it would be more appropriate to extract amended section 167 of the Central Motor Vehicle Rules 1989. You extract it from page 55 of the brief here, A to A. In this context, it has been submitted that sub-rule 5 of section 167 provides that challans issued by a police officer in uniform or any other officer authorized by the state government through e-challan facility, physical or electronic, or in cases of violation of the provisions of the Act, any designated agency of the state government which has the capability of auto generation of challans shall be disposed of within 90 days from the date of issuance of the challan, except in case of offences instituted for prosecution by court. The submission on behalf of the petitioner is that this provision under the rules make it mandatory for a proposed offender to comply with the traffic challan and pay the fine imposed, or else consequences would follow. No forum for adjudication is available, and in that case, such a provision would be violative of the separation of powers. For the sake of completeness, we have examined Chapter 8 of the Rules of 1989, which enumerate the offences for the purposes of Section 208, which is this Section 208 of the Motor Vehicles Act 1988, which provides for summary disposal of cases. Certain offences, specific offences have been enumerated under Section 164. Rule 1. And under Rule 164, for which challans are to be issued. Which could be challenged or questioned by the proposed offender before a court of law. Even for traffic offences which are not enumerated under Rule 164, there is a provision prescribed under Section 208 of the Act of 1988 for the delineating the procedure for summary disposal. Even otherwise, the outer limit is for the final disposal, which can possibly be understood to be the time limit for either payment of fine imposed by way of challan, which is not disputed by the proposed offender, or for him to question the same before the magistrate having the jurisdiction. In that case also, the outer limit would be 90 days. Mr. Mishra has further challenged that even if this procedure is like what has been stated above, the same is not appropriate for the reason of fixing an outer limit for disposal of such cases. For a better understanding of the entire mechanism, we have requested Mr. P. Saikiel and Counsel for the State to tell this court on the next date about the exact mechanism of the functioning of the transport courts, transport courts, which functioning of the courts relating to courts relating to motor vehicle offences, and whether issuance of challan, whether with the issuance of challan to the proposed offender, contemporaneously a copy of challan is also sent to a court or not. list this matter for further hearing on.
My
We
lord,
are giving 2 weeks.
subject to your lordship's convenience. If it can be fixed, my lord, either 5th of August or 7th August. So
As you say, 7th of August
this will be for further hearing, my lord.
for further hearing.
Because there is one aspect of the matter here, what you
Yeah, for further.
indicated, that I'll have to.
Prima facie, this is the issue where we got stuck up.
Right.
Pleasure hearing you, Mr. Mishra.
My pleasure, my lord. दूसरा वाला तो अलग हो गया दूसरा वाला तो अलग हो गया